Natural Resources, which houses its oil, gas, power and mining practice areas, shipping, aviation, and international trade. And Corporate Securities and Finance, wherein sits its M&A practice as well as its project finance and private equity practice areas.
We hope that, first of all, you'll have a very nice and pleasant time with us, and you'll come away with something that you'll find useful for your own endeavor, for your own business, for your own enterprise. Welcome to Bango and Godalo.
Trade and Corporate Securities and Finance, wherein sits its M&A practice as well as its project finance and private equity practice areas. Representation.
We hope that, first of all, you'll have a very nice and pleasant time with us, and you'll come away with something.
To Lagos Business School, you join the community that's made up of not only the staff and employees of Lagos Business School, but everybody who has participated in any program at the Lagos Business School. Our mission is to develop responsible managers for Africa and the world at large. And indeed, the first Chief Executive Program participants of Lagos Business School coined the term the oasis of sanity to describe Lagos Business School. And therefore, as part of the community of Lagos Business School, we expect that every member of that community will be focused and committed to ensuring that we develop professional managers for Africa and also that we influence society. And how do we go about influencing society? By all the things that I hope that you have learned or that have been strengthened by your time at Lagos Business School. When you attend any of the programs at Lagos Business School, we make bold to say that in terms of the content, you will get the same as you get in any world-class business school in the world. And we make that promise because we have attained international accreditations from the two topmost accrediting bodies in the world. And we will only get that accreditation if they believe that the quality that we offer is the same as offered in top business schools of the world. But where we're different is that we talk about the peculiarities of doing business in Nigeria and Africa.
The significance of the LBS Talent Forum is actually to help companies identify the talent that they need for Africa and for Nigeria. One of the high points is really having the CEOs of some of these respective companies dialogue firsthand with some of the talent that we have, and also discuss issues of topical interest that will help shape how Nigeria's economy improves over time.
There's no organization in the world that can grow without talent. The need to seek new talent is perpetual. So we're naturally looking for people that possess the skill set required to solve today's problem and provide solutions to tomorrow's problem today.
I think it's been very insightful. A lot of research has gone into all the various presentations that were done today, and we would expect that, taken from the learnings of today, they would go back and actually activate and actualize this, and also be part of the change agent for our economy.
I'm looking for people who are creative, innovative, who don't mind to get their hands dirty. Our job may seem glamorous, but we need people to be very hands-on and people who have an entrepreneurial spirit.
We've had a few LBS candidates in our company the past few years, and we have nothing but praise for them. right? They help the company move forward. They understand the market, they understand the environment, they understand how to navigate this environment. Most importantly, they educate the company on how to do business in Nigeria.
I'm actually looking to go into the FMCG line, maybe marketing, product management, strategy, so I've gotten a lot of feedback as to how these different FMCGs work.
I think that from the interactions I had personally with some of the organizations, that the future seemed bright for us. It seemed like they would take us in for internship, and if not, they are also looking at taking us as full-time employees in 2 years' time, I think. So the experience today has been insightful and good in all of it.
Our experience was overwhelming, very engaging students, very warm and ready to let people know what they have to offer.
I think LBS is doing a great job, and we are very happy to partner with them. Anytime we have to give we're happy to come.
So good coming back to my alma mater because I was recruited from a setting like this. It's all joy for me. It's interesting to be on this other side to also experience what my recruiters experienced when they were talking to me.
It's actually a very fantastic opportunity to be back as an alumni. I was just a student barely a year ago, and coming back from and being a part of the other side, coming to recruit, talking to students, gives me so much joy.
I think Nigeria's trade channel structure can be described as very traditional. It is fragmented. It's estimated to be about 1.2 million stores that FMCG products have to go through, traditional FMCG stores have to go through. The fragmentation means that you have a lot of smaller size stores, and they make up about 95% of the stores. In terms of contribution, the traditional stores deliver about 95% to sales. The other 5% is the modern trade. And that modern trade is the big superstores and supermarkets that are now evolving, and e-commerce. But those are in the early phases. But overall, the Nigeria trade channel for FMCG is very traditional and very fragmented. Nigeria is a very large country. We have nearly 200 million people. You do have 1.2 million stores, like I said. But what happens is that this evolution with modern trade starting to grow in terms of contribution is actually across Nigeria. So when you come into Lagos, you have a lot of stores from ShopRite, Spar, Urban, or Hubmart, Grocery Bazaar.
they are in their own right, these are modern stores, but the open market still holds sway in the neighborhood stores. If you go to Southwest, you have Food Co, you have Ceci stores and Akure. So in the regions you do have. If you go to Southeast, you have stores like Robin stores, having about 5 stores, now expanding modern trade structure. If you come to Southside, you have everyday store there, you have Market Square. They also play in their own part. If you go to the north, you have Sahad stores, which is very traditional modern store. So you can say that traditional structure is across Nigeria, but also the modern trade evolution is also across all the regions of Nigeria.
My name is Yetunde Anibaba. I teach analysis of business problems across the MBA and executive programs at the Lagos Business School. At the core of analysis of business problems is decision making. And one of the fundamental things we try to get across to participants is the need to have a structured approach to decision making. And as a guide for that structured approach, we'll typically take them through some fundamental steps in the decision-making process. Typically, when you want to make a decision or you're faced with a decision, whether managerial or personal, there's an objective, there's a goal, there's something you want to achieve. And being able to clarify that goal up front makes it easy for anyone else working with you to understand why you have gone the way you have gone. In fact, the objective forms a beacon that you're looking out for in the course of the analysis of a decision situation.
Okay, let me start again. Good morning, everyone, and I hope we slept well and ready for today's seminar. It's about the new CAMA 2020 and implications for business. And I'm sure we agree that with the signing into law of the new CAMA Act by President Muhammad Buhari on 17th August, the Nigerian business community seems elated, given the revisions and the new additions that the new CAMA is a big improvement from the Repeal Act of 1990. Challenges, however, remain. First is the need for a detailed understanding of the 870 sections of the new Act and the business implications. For instance, the demand for an increase in the number of non-executive directors and the provision for single-member shareholder. What are the potential costs and benefits to a firm? Second is the need for further examination of the potential functionality of the new Act vis-a-vis new business environment and codes of corporate governance. How will CAMA 2020 impact on corporate governance practices in Nigeria and vice versa? And third, are there areas of concern to relevant stakeholders that should be further considered as Nigerians get ready to apply the new CAMA 2020? So I'm sure we've heard so much about CAMA 2020. And to help us to examine some of these issues, we've arranged a set of experts in this field. Let me start by introducing some of our experts. But before I do that, I would like to share the agenda, the way it will go today. So just give me a second. Let me upload my screen on the way it will go today. So just give me 1 minute, please. So I'm sure you can see my screen. So after this introduction, we will have the keynote address. And the keynote address will be given by Mr. Aswe Godalo, which I will talk about in a minute. Then that will be followed by remarks by Alhaji Gaba Abubakar, Registrar General, Corporate Affairs Commission. After these remarks, we will go into the first panel session, which will focus on corporate governance, and we hope to start it from 10 a.m. to 11:30 a.m. Then there will be a short break for 10 minutes from 10:30 to 11:40. Then we'll go into the second session, which is ease of doing business, that will run from 11:40 to 1 p.m. Then there will be a closing remarks by Dr. Jumoke Oduwole, Special Advisor to the President on ease of doing business, and Secretary Special Enabling Business Environment Council. So based on this, let me just, let me stop sharing my. So based on this, because of the way we've arranged it, our guest speaker is, I'm not sure I'm supposed to read out his profile, because his profile is already a public knowledge. Of course, you know, there are some people that you don't really read their profile because they're already well known. But let me say, for the purpose of this seminar, that Mr. Aswe Godalo is among the top lawyers we have in Nigeria, especially in the corporate law, and also is well known in corporate field in terms of his board membership. It will also be nice to note, I'm sure he would talk about it a little bit, that with CAMA 2020, many people will now start telling us how many boards where they have significant interest, and Mr. Godolo is one of them because he sits on several boards. So with CAMA 2020 now, he's most likely going to relinquish his position in some of the boards. I'm not sure there's anything I will talk about him that you will not know. Well, let me say that maybe you might not know that he's a Nigerian, he's a lawyer, and he's a very hardworking man. So on this note, let me invite Mr. Aswe Godalo to give his keynote address.
Thank you very much, Franklin. Good morning, distinguished ladies and gentlemen, and welcome, and thank you for coming up so early this morning. I hope we're all keeping safe in these very difficult times. We need to. First and foremost, I'd like to thank the Lagos Business School, the dean and faculty, for inviting me to be the keynote speaker at this webinar. My hope is that we will use our time together today to critically analyze the newly enacted Companies and Allied Matters Act and how it should positively impact the Nigerian business climate. I'm also hoping that during the course of our discussions, we will also bring up provisions contained in this new law that may require a second look. I know it's a new law, but we already see areas in which we think sooner or later we need to start looking at this law again. As you may all be aware, on the 7th of August 2020, the President of the Federal Republic of Nigeria, President Muhammadu Buhari GCFR, assented to the new Companies and Allied Matters Act, which replaces and repeals the Companies and Allied Matters Act, Cap C20, Laws of the Federation of Nigeria 2004, which was actually enacted in January 1990. To contextualize the importance and need for the amendment of our company law, it's necessary to highlight the history of the development of companies law in Nigeria, and to also clearly state that in a fast evolving world, with the rate of technological advancement, types of new commercial transactions and structures, the complexities of financial instruments and types of securities, and the pace of trade, 30 years is way too long for a comprehensive review and update of our principal company statute. The first indigenous companies legislation in Nigeria was enacted in 1912. That was the Companies Ordinance of 1912. It was thereafter replaced by the Companies Ordinance of 1922, which was then amended first in 1929, then in 1941, and finally in 1954. In 1968, it was clear that we needed a complete overhaul of this law, and the Companies Decree number 51 of 1968 was enacted to facilitate the growth of our economic activities at the time. The 1968 Act introduced the concept of filing annual returns, holding meetings, and the compulsory local incorporation of foreign companies intending to carry on business in Nigeria. However, it soon became clear that the 1968 Act, which derived from the 1948 UK Act, did not appropriately cover the field for the pace and complexities of economic growth at the time. The Ogunbanjo Company Law Review Committee was established in 1988, and the Companies and Allied Matters Act of 1990 was promulgated from the outcome of the work of that Ogunbanjo Committee. In the course of this speech, for ease of reference, I will be referring to the Companies and Allied Matters Act of 1990 as the repealed act, and the Companies and Allied Matters Act 2020, which is the new act, as CAMA 2020 or the act, so that we can easily distinguish between both, because I will be going between both as we speak. The repealed act was modeled after the English Companies Act of 1985, which has also since been amended and replaced by the UK Companies Act of 2006. Over the last 30 years, companies and businesses have had to rely on the repealed act, which became antiquated day by day. By the beginning of the 21st century, it had become clear that the repealed act needed to be amended to accommodate business realities in a fast-changing world. CAMA 2020 has been in the works for about 4 years and is a really welcome piece of legislation. And I commend the National Assembly and the Presidency and all of those who participated in ensuring the enactment of this law. It introduces provisions which will minimize the compliance burden on small and medium enterprises and may promote a cost-effective business climate in Nigeria. The law has 878 sections, which is 258 sections more than the repealed act, and is in 7 parts. Currently, Nigeria ranks as number 131 out of 190 countries on the World Bank's Doing Business Index. But we expect that with the proper implementation of CAMA 2020, we will create a better enabling environment for doing business and thereby facilitate an improvement of our rankings on this index. CAMA 2020 simplifies the requirements for incorporating companies and also in most parts simplifies and clarifies company operations. Some of these provisions include the reducing the number of individuals required for the incorporation of private companies from 2 to 1, which favors small-scale entrepreneurs and makes it easy for them to incorporate without having to get additional shareholders or dilute their equity interest. But there's a downside to this because if the single shareholder suddenly passes on or something happens, there's certain issues that may also happen. The recognition of, the new law also recognizes electronic signatures. As regards the establishment of companies limited by guarantee, it provides an alternative to the consent of the Attorney General. It enables the re-registration of unlimited companies as private limited companies and the re-registration of public companies as unlimited companies. And this, I think, also derived from the demutualization issues at the stock exchange, which shows response to changing times. The new law also provides for exemption from registration by foreign companies by application to the minister. The old law required that you apply to the president, but this new law makes it a bit easier that you apply to the Minister of Trade and Investment. The new law also makes provision for an alternative to sealing documents. So it provides for signing by officials, directors, and secretaries as alternatives to sealing the documents. The new law enables the acquisition by a company of its own shares, the share buyback, and I'll talk a bit more about this, and that is a really welcome development. It permits companies to validate shares that have been issued improperly, and it relaxes compliance requirements for small companies. So it allows a lot more in the informal sector to enter the formal sector. It also permits small companies and companies having a single shareholder to hold statutory and annual general meetings virtually. Unfortunately, this wasn't extended to public companies, and we'll talk about that later on too. CAMA 2020 also obliterates the concept of minimum authorized share capital, which stipulated 10,000 for private companies at 500,000 naira for public companies and replaces this concept with the minimum issued share capital, with the minimum number of shares that must be issued by a company at any given time. So now, private companies will be required to have a minimum issued share capital of 100,000, which they must issue immediately. And public companies will be required to have a minimum issued capital of 2 million naira. Interestingly, CAMA 2020 retains most of the provisions of the repealed act with respect to the duties and responsibilities of directors. However, it introduces certain corporate governance requirements, such as the minimum number of independent directors, which Franklin alluded to in public companies. By section 275 of CAMA 2020, public companies must have at least 3 independent directors. Now, corporate governance code prescribes 2. The law specifically provides that an independent director must not directly or indirectly own more than 30% of the shares or other ownership interests in the company. This requirement for public companies to have a minimum of 3 independent directors is a bit contrarian to the ease of doing business mandate, as companies now have to balance the need to meet this requirement with having executives and also representatives of majority or major shareholders on the board, whilst ensuring that appointees are knowledgeable and have the expertise to make the correct call on issues of strategy and management performance. At the same time, ensuring that the board is not too large. Also, this requirement does not cater for companies which desire to and can have small boards, i.e. boards with between 4 to 7 directors. The Act also fails to contemplate that in real life, due to the dispersed nature of public company shareholding, holders of shares constituting 20% or more of the total shares in most public companies can control these companies as if they owned absolute majorities. So the 30% requirement, I think, is a bit too flexible. The restriction on multiple directors in companies. Pursuant to Section 307 of CAMA 2020, a person is prohibited from being a director in more than 5 public companies. This confirms but narrows also the provisions of the Nigerian Code of Corporate Governance, which recognizes that directors may hold concurrent directorships, but provides that directors should not be members of boards of competing companies to avoid conflict of interest, breach of confidentiality, diversion of corporate opportunity, and divulgence of corporate information and secrets. India, which currently ranks as number 63 on the Ease of Doing Business Index by its own Companies Act 2013, allows a person to be a director in a maximum of 20 companies, only 10 of which can be public companies. I am in support of this restriction on the number of directorships a person can hold. Franklin, are you surprised? But I am in support of this restriction. I believe that the role, responsibilities, and duties of directors and the information and document they need to grasp are so copious, vast, sometimes complex, and so serious that the diligence required for effective performance dictates that directors, no matter how experienced, must not be overstretched. So I'm in favor of that restrictive provision. The disclosure of substantial interest. Section 120 of CAMA 2020 reduces the threshold of what will amount to substantial shareholding in public companies from 10% to 5%. It provides that a person, and this aligns with SEC provisions, it provides that the person who is a substantial shareholder, directly or indirectly, it creates a concept of beneficial ownership, shall give notice in writing to the company. Where a company receives notice that the person has acquired substantial interest in a company directly or indirectly, the company is obligated within 14 days of receipt of the notice of becoming aware that a person is a substantial shareholder to in turn give notice in writing to the Corporate Affairs Commission. Failure to notify the Corporate Affairs Commission attracts a fine, as the CAC may prescribe by regulation. Disclosure by directors of interest in contracts. And I think this provision is a also a very welcome provision. Pursuant to Section 303 of the new Act, directors are now required to immediately notify the company in writing where the director is directly or indirectly interested in a transaction or proposed transaction involving the company. Although disclosure requirements were contained in the repealed Act, the repealed Act did not require immediate notification. It allowed you to notify at the next possible opportunity, or at the next possible meeting, or at the next opportunity when the issue comes up, and didn't specify immediate notification. So I think this is a welcome change and puts an obligation on directors who are going to be conflicted to immediately notify the company and disclose. The issue of statutory separation of the role of chairman and CEO. This has been a governance prescription. It's in the SEC code, it's in the Nigerian Code of Corporate Governance. It's also in the bank code, in the central bank code. And I think it's a very welcome development. By the provisions of Section 2656 of the Act, the corporate governance concept that the chairman of a public company cannot also be the CEO of the same company has been introduced. And like I said, I think this is a very welcome development. I think for issues of effective and proper governance, both roles must be separated and must be distinct so that the proper oversight functions can be duly effected. Some other key provisions of the new law include the pre-action notice. By Section 17 of the Act, there's an introduction of a procedural requirement of a minimum of 30 days pre-action notice before you can commence an action against the Corporate Affairs Commission. It is expected that this requirement will reduce frivolous litigation, encourage out-of-court settlement of disputes, while also narrowing issues to facilitate a cost-effective judicial process. And I think it's also in the best interest of clients and operators. Also, there's the recognition of limited liability partnership, which I think is a fantastic and welcome development, and which is the way the world is going. Prior to this time, business activities in Nigeria could be undertaken only through the following legal structures: private or public limited company, unlimited liability company, company limited by guarantee, incorporated trustees, and business names. Partnerships were not considered corporate bodies or separate legal entities, and the limited liability of partnerships were not recognized under Nigerian law. But in the new law, Section 746 to 810, there's now a recognition of limited liability partnerships and limited partnerships as corporate entities. And these entities are acknowledged as being separate from their partners. They can sue and be sued in their name, have perpetual succession, and can acquire, hold, and dispose of properties in their name. Similar to the requirement for foreign companies that intend to carry on business in Nigeria to first incorporate in Nigeria, Section 788 of the new law requires foreign limited liability partnerships that intend to carry on business in Nigeria to take necessary steps to be incorporated as separate entities in Nigeria. Essentially, limited liability partnerships and limited partnerships are well suited for establishing private equity funds and service firms because of the organizational flexibility they provide, limited liability nature, and tax transparency. Power of companies to allot shares. Under the repealed Act, the power of companies to allot shares could be delegated to the directors of any type of company. However, by the provisions of Section 159 of the new law, the power to allot shares is now vested in the company. And in relation to a private company, this power may be delegated to the directors, subject to any condition or direction that may be imposed in the articles or by the company in general meeting. However, Section 127 provides that an increase in the share capital in a company shall be done by allotment of new shares only at a general meeting and not otherwise. So if you read sections 127 and 149 of CAMA together, there appears to be an interpretational problems as private companies that have been permitted under 149 to delegate the power of allotment to the board of directors are unable to proceed in this manner due to the provisions of Section 127 that has made it mandatory for an increase in issued share capital by an allotment of new shares to be authorized only at a general meeting. Also, in practice, the provisions of Section 127 may hinder public companies seeking to undertake an equity capital raise. It will appear that such public companies will need to convene 2 general meetings in a capital raising process. The first meeting to authorize the company to undertake the offer, and the second meeting to authorize the allotment of shares following subscription by investors. And this can make this process a bit more cumbersome. There's also the provision of preemptive rights of shareholders. By Section 142 of the Act, a company shall not in any event allot newly issued shares unless they are offered in the first instance to all existing shareholders of the class being issued in proportion as nearly as may be to the existing holdings. This is the provision of preemptive rights. This has raised concerns. This was there in the old law for private companies, but it now covers all companies. And it has raised concerns amongst managers and officers in public companies and potential investors, as is a major deviation from the provision of the repealed acts, which only specified preemptive rights for private companies. I think I align with these concerns, as this provision may restrict public companies intending to undertake equity capital, as the provision implies that they would not be able to make public offers to undertake private placement or undertake private placements without first going through the process of formally making an offer to all of their shareholders. This will again also make that process a bit more cumbersome. There's also the issue of financial assistance for share or company acquisition. And I think this also is a welcome development. This is a new development and a welcome development. The old law restricted this process. Generally, laws prohibiting financial assistance are deemed to be outdated and not in tune with current day transactional realities because of the difficulties they pose in financing acquisitions and leverage buyouts. In order to mitigate these difficulties, the new law introduces the concept of whitewash procedure. This will enable shareholders to authorize transactions which will have otherwise been void. The procedure can be used by purchasers or has been used by purchasers in certain other jurisdictions to fund acquisitions by using the assets of the target company to secure borrowings, which were thereafter used for the payment of the shares in the company. This also will be done pursuant to approval by shareholders. Under the new law, Section 183 permits financial assistance by a company in furtherance of anything done in pursuance of an order of the court under a scheme of arrangement, under a scheme of merger, or any other scheme or restructuring of a company done with the sanction of the court, or by assistance given to the company where its principal purpose in giving the assistance is not to reduce or discharge any liability incurred by a person for the purpose of the acquisition of shares in the company or its holding company, or the reduction or discharge of any such liability. But it's done as an incidental part of some larger purpose for the company, and the assistance is given in good faith and in the interest of the company. This enables some latitude to directors and to the company to be able to provide this financial assistance for its company in cases of acquisition transactions and leverage buyouts. There's also the provision of acquisition by a company of its own shares, which I think is also a very welcome development and in line with what is happening globally. And it also helps strengthen the valuation of companies. In line with international practices, Section 184 of the new law enables a company more easily to acquire its shares. The old law made these prescriptions too, but it was a more tedious process. This is a welcome amendment to the buyback provisions of the old law, as it eases this process. Share buybacks typically help businesses reduce capital costs, and it improves shareholder value. There are also provisions for company rescue proceedings and insolvencies, which I think is a great and welcome development. And I also think that this provision would have, if it was in place a few years ago, would have salvaged certain great brands that went downhill. By the provisions of sections 434 to 549 of the Act, this concept is introduced, and it will assist companies who are in financial difficulty. The provisions include the ability to convert winding up and receivership proceedings to a process of administration, the ability of financially distressed companies or companies likely to become financially distressed to partake in a business rescue reorganization, such as a company voluntary arrangement and administration, as an alternative to being wound up. This also includes the suspension of the enforcement of securities, court actions, sequestration of assets, while a company is undergoing administration. And so this gives the company some latitude and some breathing space. A company is also now able to disclaim onerous contracts with the leave of the court. Also, where undervalued transactions may have led to a company's financial distress, the company can obtain an order of the courts restoring it to its previous position. During winding up and/or a reorganization, contracts for the supply of essential services can also be entered into or continued on the basis that the supplier obtains a personal guarantee of the office holder in charge of rescuing the company. Additionally, the monetary threshold for determining insolvency has been increased from 2,000 naira, which wasn't in line and in tune with present-day realities, to 200,000 naira. I think this insolvency provisions are a really welcome provision, and I applaud the makers of this law for including this in our law. In addition, by section 718 of the Act, there's the introduction of netting provisions, which involves offsetting or reducing exposure or obligation by combining two or more obligations to achieve a reduced net obligation. The benefits of netting include the reduction of settlement, liquidity, or credit risk in a company. This also enables derivatives and swaps and other over-the-counter transactions by providing the legal and credit protection for these transactions. This provision is highly commended, forward-looking, and in line with the evolution of derivative transactions. Now, I'd like to quickly talk about the issue of incorporated trustees, and I know this has generated a bit of heat in the last few days. The new law retains the provisions of the repealed Act with respect to the registration of incorporated trustees. Section 850 of the new law provides that an association, including incorporated trustees, may be dissolved by the court on a petition brought for that purpose by 1, the governing body or council, 2, one or more trustees, 3, members of the association constituting at least 50% of the total membership, or 4, the Corporate Affairs Commission. This is in line with the old law. But the new law now introduces a section 839, which permits the Corporate Affairs Commission to suspend trustees of an association and appoint interim managers to manage the affairs of the association, where it reasonably believes that A, there is or has been misconduct or mismanagement in the administration of the association, B, it is necessary or desirable for the purpose of protecting the property of the association, securing a proper application for the property of the association, towards achieving the objects of the association and the purposes of the association, properly securing the property and the other properties of the association, and or it is in the public interest, and C, that the affairs of the association are being run fraudulently. I believe that this is the provision that has occasioned a lot of, generated a lot of heat amongst established charitable organizations. And I think that from my perspective, I don't think the reasons for the heat are well-founded. This provision has been taken from the charity law of the UK, and I think the amendment seeks to establish checks and balances in the operation of incorporated trustees. If you agree to be incorporated under our laws, I think should be subject to some or certain levels of oversight. The power of the Corporate Affairs Commission to suspend the trustees of an association is not an absolute power. And the activity and the acts of the Corporate Affairs Commission is subjected to court oversight upon the petition of members consisting 1/5 of the membership of that association. Like I said, I think the public reaction to this amendment is a reflection of the distrust that we have for our regulators and the manner in which our regulators exercise their powers. I think if this underlying distrust wasn't there, the heat that this provision has generated would have been minimal. The new law also now reintroduces a framework for implementing mergers. When by the enactment of the new Federal Competition and Consumer Protection Act, sections 118 to 128 of the Investment and Security Act was repealed, that created a gap in the legal process and framework for merger transactions in Nigeria. I am really happy that this gap has now been effectively plugged with the reintroduction of merger provisions in section 711 of the Act. It makes my life easier in this space, and it makes things really clear. So I applaud the makers of this law for reintroducing section 711. The new law also now prescribes the power of fines and vests this power in the CAC, Corporate Affairs Commission, by regulation. The old law specified these fines in the law, but the new acts has vested these powers in the Corporate Affairs Commission. I think this is a welcome development because these sanction provisions in the old law were totally outdated and did not serve as effective deterrents. Hopefully, the Corporate Affairs Commission will prescribe fines in tune with present-day currency values, and such sanctions will be commensurate to offenses committed and will be fairly and equitably applied. So, what next? Section 869 of CAMA grandfathers what has been done under the old law. It provides that any other rule, regulation, appointment, conveyance, mortgage, deed, or agreement made, or resolution passed, direction given, procedure taken, instrument issued, or anything done under the repealed act, and any amendments thereto, shall remain in force as far as it can be made, it can be passed, given, taken, issued, or done under the new act. So it shall have effect as if it has been made and passed under this act. So that is a saving provision and is very welcome. And most well-made laws have this kind of provision. It further provides that nothing under the new act shall affect the incorporation of any company registered under the repealed act. Accordingly, this saving provisions empowers entities to continue with transactions of activities that were approved under the repealed act. However, and nonetheless, my advice is that companies and their advisors should conduct a proper and detailed review of the new law and ensure that their articles, their documents, their records, and their processes all comply with the provisions of the new act as soon as possible. Also, although the act tries to cater for all types of business entities, structures, operations, and governance procedures, it is not a cure-all document or a silver bullet document. And it has some uncovered, unclear areas, which I am certain will be discussed at length in the course of this webinar. Whilst it amends and addresses a number of the loopholes which we noted in the repealed act, it would appear that the introduction of some oversight provisions in this law and some concepts may suggest an overregulation of companies and overregulation of company practices. I believe that there are specific sections of the act which should ideally have been amended, or new provisions that should have been included in line with current realities. And I'll try and talk about some of these. For instance, there are no provisions for the dematerialization of shares and share certificates. Section 171 of CAMA restates what was in the repealed act regarding the issuance of share certificates. And in this day and age, I believe there should have been provisions for dematerialization of shares. And this is a very critical and I think an unfortunate oversight. I also want to touch on compliance by small companies. The prescribed easing of certain disclosure requirements and filing by small companies, while it appears to reduce their costs and enables a lower barrier of entry for these companies at the onset, may affect and plague these companies as they grow bigger, want to raise capital, or want to divest interest to third parties, because they need to have financial and other records that are in place. And if they are not encouraged to stay compliant, there's the possibility that they'll run into difficulties when they become bigger companies. Also, they may not have developed appropriate compliance and good governance cultures, and this may affect long-term sustainability. I know that one-man companies sometimes have difficulty in complying and working with compliance processes and good governance cultures, regardless how successful these one-man companies are. Sometimes corporate accounts and personal accounts are interchangeable and more or less the same, and the proper filings haven't been done. And where people have not cultivated an effective governance culture and a compliance culture, it then becomes even more difficult as the company grows bigger for them to comply. So I think in this regard, the CAC has to think through by regulation and effect some balancing. There's also the issue of electronic meetings by public companies. And despite the fact that this law was assented to 4 months into COVID, and after many public companies struggled to hold their annual general meetings, we were not nimble enough to make provision in this law for the electronic holding of general meetings by public companies. And this, I think, is a grave oversight. I think we should have inflected some nimbleness in our processes and quickly gone through a process of including this. I know it's tedious to go back to the National Assembly, but this is an oversight and something we'll probably have to deal with, considering the current realities of our time. Hopefully, this issue and other observed legal gaps or provisions that in practice are pragmatic will be the subject of a quick amendment to this law. We also must work to have a detailed and comprehensive upgrade of this all-important law at least every 5 years. This will be in tandem with commercial, technological, business, corporate and transaction evolution and developments, and international best practices. The world is moving at a fast pace, and our lawmaking, especially for our critical business laws, must be at pace with international developments. There's also the issue of Section 1471, which proscribes the issuance of irredeemable preference shares. I do not agree that that government or statute should determine the type of instruments that companies can issue to raise capital. The market should be expanding and we should be encouraging the creation of more instruments. We should have more instruments available to companies to enable them raise capital from the market. The appropriateness of financial instruments redemption, the structure of those instruments should be reserved to shareholders once the structure is effected within the confines of the law. So I do not agree with this provision. However, generally looking at the law in its totality, notwithstanding some of the shortcomings I've raised and others, I firmly believe that the Act is a firm step in the right direction and will encourage investments, particularly with respect to small-scale enterprises and private equity funds, who can now be registered as limited liability partnerships. This will also encourage flow of investment into the country. The law also encourages businesses in the informal sector and one-man businesses to move into the informal structures. So I think this is also a very welcome development. I applaud the new insolvency and netting provisions, and I have said this, and I think it's great thinking. And like I said before, if it had been in place a few years ago, I know many brands which would have been salvaged. I am particularly pleased with the reintroduction of the merger processes. Given the powers now vested in the Corporate Affairs Commission to prescribe fines and penalties, and the apprehension in the market that this will make the Corporate Affairs Commission yet another super regulator, I hope that the Corporate Affairs Commission will utilize its powers fairly and transparently, always assuring a level playing field, which is always the worry of operators, that our regulators do not always assure a level playing field. The Corporate Affairs Commission must be mindful of the country's level of development and the necessity to attract and sustain local and foreign investments when implementing this new act and administering its prescribed regulations. Nothing destabilizes investors and is more off-putting than an uncertain environment, the arbitrary use of discretionary powers, and the lack of regulatory transparency. It's totally off-putting, and it totally destabilizes investors, and is totally inimical to the free flow of investments into any economy. Now that the long-awaited act has been enacted, we must all collaborate and work together as individuals, business owners, thought leaders, investors, or regulators to ensure that we create an environment that enables the creation of an economy that assures inclusive growth and leapfrog development. We await the well-considered passage or proper review of other economy-enhancing laws such as the PIB and the ICRC as we reform to build a better country. The private sector working as one with the common goal of assuring a properly and equitably developed Nigeria where no person is oppressed, forsaking those personal advantages that are inimical to public good and national interest, must work harder. We must work better and more creatively to assure the Nigeria of our dreams. I thank you all for listening, and I hope I've set the tone for an effective conversation for the rest of the day. Thank you very much.
Thank you very much, Mr. Ighodalo. I'm sure that many of us are feeling very excited, properly educated. I personally feel that I have now become a chartered CAMA expert. So just from this your lecture. So anybody that wants to talk about CAMA now, I can confidently say I know a lot about CAMA. So thank you very, very much. Let me also say
thank you.
That we also know that after a presidential address, the president does not take questions like that. But the Minister of Finance, Minister of Budget, and other key cabinet members will take all the questions. So all the questions you have, we've assembled the best of bests that will answer all the questions. I can see many questions already coming up. But because of certain protocol, we will excuse Mr. Ighodalo from taking questions because we have assembled all the experts that can take all the questions you have. Let me say also that
frankly, let me say something. Let me say something though. I would have loved to stay to take questions. It's just that I have a certain obligation in 10 minutes, but I will come back once I finish that obligation on the National Development Plan. So I will come back.
So you can see that he's even willing to break protocols and take questions. So
I will come back, yes.
Which is very, very commendable. But let me say that the people that we've assembled, I'll talk about them in a few minutes. They are the best. And of course, this is a webinar by LBS and Banwan Ighodalo. So it's a partnership between two of us. And we've assembled the best, starting from Professor Chris Ogbeche, who we all know, Professor Wala Ajayi, Toyin Bashi, Shei Bella, Aziza Muse Sadiq, Olumide Oshundolore, and my humble self. And I can guarantee you that at the end of the day, you'll be better informed, particularly in issues of ease of doing business and corporate governance. On this note, based on this excellent lecture by Mr. Ighodalo, let me invite the Registrar General of Corporate Affairs Commission, who has been with them since 2004, to give a few remarks. Alhaji Gaba Abubakar, please.
Thank you. Good morning, distinguished participants. I want to especially thank Mr. Ighodalo for the excellent lecture. I don't know if I have anything much to say after that extensive brief on the new issues in CAMA, the new CAMA. But anyway, CAC is the implementing agency, and we are glad we finally have a new law after 30 years. We didn't behave like Kenya that adopted wholesale the provisions of the English Companies Act 2006. We had to look at our own peculiarities as a country, and because the lawmaking process and law implementation is an evolving process. We didn't just want to adopt practices that may not be applicable immediately to us. But as we move along, some of these changes, as Mr. Ogadalo has suggested, these changes, we shouldn't wait till after another 30 years. Ideally, after every 5 years, this law should be reviewed and we should have some improvements. What the new law has done, we have an enlarged board with the addition of the Institute of Chartered Secretaries and Administrators, the Federal Ministry of Finance, and because of the role of small and medium enterprises to our economy, the National Association of Small and Medium Enterprises has been added on our board. So we have a 12-member board now. The law has, as has been mentioned, is divided into 7 parts. We have 2 non-legal entity types, LLP and LP. And we have 168 new provisions, while 91 provisions were modifications of some of the provisions in the former law. As the implementing agency, we don't know it all. So we intend to approach these issues differently, different from what had transpired in the past. In the past, CAC issues regulations and guidelines without even the involvement of stakeholders. For the first time in February this year, we exposed our revised checklists and guidelines to our key stakeholders. And we even had an interactive forum with the SBL in Lagos, where these checklists and guidelines were discussed. We intend to adopt the same approach with the regulations that will be issued pursuant to this law. Although it's the Honorable Minister that makes these regulations, we've already worked on a working document in-house, and we'll expose it to key stakeholders for their input. After we have collected all the inputs, we'll have a small committee comprising some of our staff and key stakeholders like the Nigerian Bar Association section on business law, Institute of Directors, and other key stakeholders to review this working document so that all relevant stakeholders will get stakeholder buy-in before this regulation is approved by the minister. Another issue we intend to give very serious consideration to is the issue of enabling electronic platform for transactions. No matter how beautiful this law is, you cannot achieve success without a robust electronic platform that will allow companies and other stakeholders to do their transactions with CAC remotely. Company law regulation and practice has moved beyond what anybody can imagine. In other jurisdictions today, you have end-to-end electronic solution for registration of companies and management of company accounts. We intend to adopt the same approach in the CAC, where every company will have its username and password. They may decide to create other users, either their company secretary or anybody. That is not to say that we are going to dismiss the current practice of accredited customers, that is accountants, lawyers, and chartered secretaries. But in addition to that, every company will have its unique username and password, and it can make its own filings directly, or they may choose to do it through their agent, either a lawyer, an accountant, or chartered secretary. And this will not just be limited to new registration services. It will extend to annual returns and all other disclosure requirements, change of directors, and other things relating to the company. We are also looking at the option of introducing XBRL system, extensible business reporting language for financial statements. This may not be immediate, but it's part of our long-term plan so that financial statement will be submitted in an extensible reporting language. Individuals or stakeholders that need information on any financial statement can obtain it and analyze these reports in a manner they desire. So these are some of the changes that we're working on. On the new electronic platform, we are seriously working to ensure that we have an end-to-end electronic solution between now and December, such that for all aspects of our services, companies and other stakeholders can engage CAC and do their transactions remotely without having to visit CAC. Only yesterday, my attention was drawn to a fake gazette that has been in circulation. I want to use this medium to dismiss that. The law has not been gazetted yet. We are working with the National Assembly to ensure that we achieve this gazetting as quickly as possible. The cover page on circulation is actually fake. We've confirmed this from Federal Government Press. The process is still on. So I'll call on all our stakeholders to dismiss what they have seen. We are working with the National Assembly, and this thing will be achieved as soon as possible. We are also working on a new system altogether for registration of limited partnerships and limited liability partnerships, such that we don't want to include it in the current application because of the challenges. This new system was developed in 2017. We still have issues deploying all aspects of the application. So we don't want to entrust the same vendor to do the same thing. So we've already advertised, inviting companies that have the wherewithal to bid for, first with expression of interest. After we have received application for expression of interest, we'll qualify those that will move to the next stage of submitting financial bid. So even though implementation in relation to companies, business names, and incorporated trustees may start immediately, for LLP and LP, that may have to wait until we have that new system. So another issue has to do with the Administrative Proceedings Committee that has been established by Section 851 of the Companies and Allied Matters Act. This will actually help significantly in reducing cases of dispute. We'll use mediation as a very good tool to resolve disputes amongst directors and shareholders. CAC does not know it all, and I want to assure our stakeholders that we'll consult widely in all our programs and actions, and starting with the regulations, as I have said, will involve all stakeholders, and moving forward, anything that requires input from the public, we'll expose it on our website, and we'll write to key stakeholders for their input. So CAC will carry everybody along, will not be draconian, and even in issuing guidelines and penalties for non-compliance with this law, we'll be mindful of the economic situation in the country. We may have to make distinctions between companies that can afford to pay these fines and small companies that may not necessarily have the money to pay these fines. So we may have discriminatory fines, maybe based on turnover. I'm just alluding to it. That will depend finally on what the enlarged committee come out with. But we are looking at differential fines based on the type of companies and based on the turnover threshold of these companies, so as to encourage small and medium enterprises to continue to engage in their own activities. The issue of small companies is a good innovation, but as I have said in other events, the issue of one-man company for a small company is only limited where a company other than a small company has one shareholder. The law says it must have 2 directors. So we have to be mindful of that. Although the determination of when a company qualifies as a small company will only come into effect after their first annual returns, because the company has to carry on some activity before you determine the turnover threshold and the net asset threshold. And as I have mentioned, the turnover threshold of 120 million and net asset threshold of 16 million in CAMA is too huge. So we are likely to align these provisions with what obtains in the Finance Act that provides for a turnover threshold of 25 million. So this will be in the regulations because a section of the law says such other amount as may be determined by CAC. On registration of charges, there has been a significant reduction on amount payable for registration of charges. The law now says an amount not exceeding 0.35% or such other amount as may be approved by the minister. We don't intend to go beyond that. So even though the minister can still approve something higher, we don't intend to go beyond 0.35%. And I think this is quite helpful particularly for public companies that were made to pay 2% in the past. When a company approaches a bank or any lender for loan, there is no distinction between a public and private. But under the former law, public companies were made to pay 2% as opposed to the 1% that was being paid by private companies. So this is a good development. And I want to thank the organizers of this event for the opportunity and assure all our stakeholders that CAC will continue to collaborate with them to ensure that this law is this law is properly implemented. And as Mr. Ighodalo has said, it's the responsibility of companies to actually look at this law, get legal advice and other advice from their accountants on the areas that will impact on their operations. We need to understand this legal framework, this new legal framework, and how it applies to us as companies. So thank you so much for listening, and I wish you successful deliberation. Unfortunately, I have a board committee meeting. I may not be with you all through these deliberations. Thank you so much.
Thank you very much, Alhaji Garba Abubakar, for that very insightful remarks. You've actually clarified a few things that people have been arguing about, and it's very good that you've also affirmed that you are still taking feedbacks, and that will be taken into consideration while you relate or interact with National Assembly to finalize the act. Thank you very much. We also appreciate your tight schedule, but we will appreciate if you can, if you can emulate Mr. Ighodalo to come back again and take questions.
When are you likely to finish? When is the event going to end?
It's ending at 1:30.
Okay, fine. If we finish the meeting before 1, before that time, I will actually join you again. Thank you so much.
We've just received a confirmation that the meeting will be finished, that your meeting will finish before 1:30. So we expect.
I don't have control over that. I will have wished to be here all through, actually. Yeah.
We appreciate. So we look forward to seeing, because I'm sure that many people will have questions for you, okay, so you can clarify further. Okay. But thank you very much for that insightful remarks. Thank you.
Thank you so much.
So thank you everybody for listening. So what we do now quickly is to go into the first panel session. And that session will be looking at corporate governance. But before we start that session, let me say that I'm sure you will agree with me that it's been a very interesting session. However, and based on what Mr. Ighodalo has said and what Alhaji Abubakar also clarified, there are too many areas that we're supposed to cover. However, for this seminar, we've selected 2 key areas which we believe affect almost all businesses. And the 2 areas include how this CAMA 2020 affects or relates to corporate governance of firms, small, medium, and large firms. We've also, after the corporate governance, we also believe that many people are looking at how the CAMA impacts or contributes to ease of doing business in Nigeria. So that will be the second panel session that we're going to have after this first one. But to help us to answer all the questions with regards to corporate governance that Mr. Ighodalo highlighted and Alhaji Abubakar also clarified, include 1, Professor Olawale Ajayi, who is a professor at Lagos Business School, is a lawyer of many years, and he will be with us to answer all the questions. Joining him will be Olumide Oshundolore, who is a partner at Banwan Ighodalo. And the third, but not the least, is Mrs. Aziza Muse Sadiq. And 3 of them will answer all the questions that we have. Aziza is also a partner at Banwan Ighodalo as well. So you will agree with me that these 3 panel members, they are experts in this CAMA 2020. And they actually contributed in terms of, as we're preparing for this webinar. So let me start by With regards to corporate governance, let me start by asking, let me just be sure. Olumide, are you here with us?
Yes, I am.
Okay, good morning and welcome.
Good morning. Good morning, Franklin.
So let me start. We are coping, praying for COVID to finally go. But I received the good news that once they open the international airport, okay, they've opened it, that COVID is preparing to leave Nigeria. it will go with international flights. So just starting with you, the first question that I would like you to answer is, what are the implications of the new provisions in this CAMA 2020 as regards independent directors? How do you reconcile these new provisions on a practical level with the provisions of the Code of Corporate Governance and the provisions of CAMA 2020, which relate to the composition of audit committees? And when do these provisions come into effect? And are there disclosure requirements for directors, especially as such disclosures relate to directors of public companies? Thank you.
All right, thank you very much. Let me start with the issue of independent directors. So by definition and description, independent directors are supposed to be directors that have no or little material or pecuniary interest in a company. And so what you then find that is that the latest trend in corporate governance is to require that the board should comprise of non-executive directors, majority of which should be independent executive directors. Now, what new CAMA has done is to require, with respect to public companies, that they should have at least 3 independent directors. So like Mr. Ighodalo has said, of course, this then brings serious challenges with respect to the size of the board. Secondly, is the fact that the law also requires that where a person has the right or the power to appoint the majority of the board members of a public company, then that person is entitled to nominate at least 3 persons who will be appointed as independent directors. This brings significant issue to with respect to corporate governance, particularly when you then understand that the reason why you want an independent director is to bring independent, unbiased view to the board. And then you have someone that then is responsible for appointing either all or significant number of the independent directors. And then, so you could argue anyway that in any case, if you give the power to the board and he's supposed to appoint majority of the board, then there's no reason why the board will not do what that controlling shareholder wants. Whichever the case may be, but the issue still remains that one of the key principles for corporate governance is an independent board, a board that is not controlled by anybody. And you then find that when you then look at the other code of corporate governance that we have in the country, the NCCG, which is Nigerian Code of Corporate Governance, simply says that the board, there should be an appropriate mix of non-executive directors, and it is desirable that most of the non-executive directors are independent directors. The SEC code, that's Corporate Governance Code for public companies, says that there should be a minimum of 1 independent director. Now, another interesting issue is the definition of the independent director. The law, CAMA 2020, says that an independent director is a director who or whose relative, together or separately, so the director or his relative, together or separately, then they own not more than 30% of the shares of the company, directly or indirectly. It also says that that they shouldn't have been employees of the company, or that the relationship, they should not have been involved in a relationship, that they must have not paid or been paid up to 20 million within 2 years of the time we're talking about. And the issue comes up that when you put all this together, you wonder whether the person is really indeed independent. Other codes of corporate governance, for instance, the NCCG, says that shareholding, if the independent director must have any shareholding in the company, it shouldn't be more than 0.1%. The Code of Corporate Governance for Public Company by SEC says it should not be more than 0.1%. With respect to relationship with the company, NCCG says that the person must have stopped being an employee for a period of 5 years, and that where the person should not be a member of the directorate of the regulator for a period of 3 years. So there's a cooling period to ensure some form of independence, at least that whatever influence that the company may have, or whatever the interest that may be inimical to independence of the candidate will have died down. But what we find here is that the time does not appear to be long enough. And meanwhile, the person is allowed to have equity interest in the company up to like 30%. When you match that against the fact that the law, CAMA 2020 also says that significant shareholding in the company, the threshold is 5%, then you are talking about total dominance of the board. And that has significant implication for corporate governance. I don't know the reason why this provision has been included, but it's important that we look into it to ensure that we do indeed have independent directorship, that the independent directors are truly and really independent. Now, with respect to the apparent conflict between the provisions of CAMA 2020 and the Nigerian Code of Corporate Governance, technically speaking, there is no conflict. Number one is the fact that CAMA is an act of the National Assembly. The code is a subsidiary legislation issued by a government agency. There's a principle of in hierarchy of legislative instruments where a primary legislation, which is usually Act of National Assembly or laws of the state houses of assembly, will rank in superiority over subsidiary legislations, which are regulations, guidelines, let me say legislative instruments issued by agencies of the government or agencies that have been created by the laws of the National Assembly. So that is on one side. The other side is also that the codes are simply advisory and not obligatory. What do I mean by this? If you recall, the NCCG provides that, number one, the NCCG is structured as principles. And under each 28 principles, you have recommended practices. And the preamble to that code says that the code has adopted and apply and explain principle, which means that the companies are assumed to have applied the principles of the code, and then they're supposed to explain how the practice that they have adopted conforms to the principle of the code. And this is to ensure scalability, so that, for instance, if the company is not big enough and the board is just 5, you cannot then prescribe the minimum number of independent director in such a case. If you say it's 3, then that means they only have 2. They will only have 2 left, and then that significantly reduces the flexibility that they have. So for purposes of flexibility, and the same thing too for the SEC code. The SEC code, that I'm talking about the corporate governance code for the company. The SEC code says that the code is not intended as a rigid set of rules. It is expected to be viewed and understood as a guide to facilitate sound corporate practice and behavior. So what would then happen really is that the people who comply are expected to comply with CAMA, and then they then need to explain how their compliance with CAMA complies with the principles of the code. But CAMA will always take precedence in these circumstances. With respect to, so another a change that also happened is with the structure of the statutory audit committee. For public companies, anyway, it's public companies that are supposed to appoint statutory audit committees anyway. Under the old law, it's supposed to be 50-50, equal numbers of shareholders and directors, 3-3. But now the law says that it will be 3 shareholders and 2 directors, non-executive directors. And what this means really is that the shareholders will then dominate the statutory audit committee, which gives the shareholders more control over the financial control system of the company. I think this is a welcome development, particularly where the issue has always been that in a public company with diverse ownership, what you find is that the directors are practically untouchable. They are actually the controllers of the company and not the shareholders, because the shareholders are too fractioned to actually do anything significant. But in a situation where they then have greater visibility and control over the financial reporting system, then it gives them more oversight over the board to ensure that proper disclosures are made. What's the other question?
Okay, thank you very much. I think, let me also say that as you've given a very fantastic explanation to these first 2 questions. I'll come back to you for the 3rd one. But based on what we've explained, let me take it to Professor Ajayi, with just based on what Olumide has explained so far. We'll come back to Olumide in a short while. But based on what he has said and going through the CAMA Act, one of the striking innovations relate to the 1-person and small companies. What are the corporate governance dimensions in your view? Professor Ajayi, please. Prof, are you with us?
Okay. Thank you very much. I was muted by the host, and I was trying to gesticulate to indicate that I was unable to unmute myself. Thanks for whoever the host is for unmuting me. Well, okay, so perhaps you're asking me about the single-person companies, but let me just quickly say 1 or 2 things about the issue of independent directors. I think the other point to bear in mind with independent directors is that it's not a panacea actually for good corporate governance, not necessarily. Because why do you have three people who may not even be necessarily versed in the industry, or hopefully they will be versed in financial affairs? So that's one aspect to it. The other aspect is that in some countries, for example, in India, the idea seems to be that independent directors feel they owe some loyalty to whoever has appointed them. Or maybe they have been appointed from foundations or other, networks that are connected with the company, so that the corporate governance benefits are not even, seen. Some of the independent directors we have on board are people who have been, in various walks of life, may even have developed what you may call cloned thinking, so that coming to the board, they probably don't bring anything really very different. There's also the point that the concept of independence is a cultural construct. And in some clients, including in Nigeria, the idea of just being independent is something that is still growing. So just having independent directors on the board doesn't necessarily, of course, bring the required level of stakeholder or what you feel stakeholder representation to the board. But in terms of having independent directors, I would have preferred a situation where it's one or two instead of three. And I really align myself with Mr. Godalo when he says this probably puts a pressure on board to have a large, on companies to have large boards. So I think this is something that really ought to be very much looked at and probably amended. Now, going back to the question, the direct question you gave me, the one person or a company. A lot of commentary has, identified the positive aspects in the sense that entrepreneurs, particularly startups, especially in the technology field, may find it easier to formalize or to start up. The other point, of course, is that it may also ensure that the large measure of informality that we have, someone is asking me to increase my volume. Okay, I will do so. I reduced it so that my earbuds will not be damaged. Right, okay, so I've increased my volume. I hope you can hear me, Ogechi. Yeah, can you? It's almost at the maximum. So I hope you can hear me. Let me try something else. Right. Okay. So is it better now?
Yes. Yes.
Okay.
I think it's better now. Yes. Thank you very much.
Thank you very much. Yes. So I don't know if you were able to hear the comments I made, but let me go on with the single person companies. I've said it's a good innovation in terms of encouraging the informal sector players to formalize. So I think that is something that we must commend. However, I really also very much align myself with the views of Mr. Godalo that then leaving them with all those exemptions. I think perhaps those exemptions should be really options, so that instead of it being that they really are excused from the various provisions that could help them to inculcate the culture of good governance, it probably should be that it should be optional. They may have one director, they need not appoint a secretary, they need not hold annual general meetings, nor appoint auditors. And even under Section 4051, the CEO of such a company does not bear responsibility for audited reports. Now, that this is also a bit curious, because you must deal with creditors, you must deal with banks, you must probably also at some stage begin to attract investments, you must deal with suppliers. So the whole idea that they do not need audited accounts, I don't know, sounds a bit fanciful. I thought the better thing is to encourage them to make use of facilities to ensure that they have proper accounting, or proper records, that they have some measure of administration, that they also sort of open themselves up to oversight, assistance. So I think perhaps CAC and some other bodies must find a way to bring in helps in terms of inculcating this culture of corporate governance, either through industry bodies or perhaps through codes, and a lot of maybe also education to ensure that the tone of corporate governance in these small companies, single person companies, is continually raised. I think that is what would be of benefit, because what we hope happens is that these companies go from small to medium to big, and that progression is there. And that progression can only be helped if the culture of willing oversight, the culture of having accounting records that are credible, the culture of ensuring that they increasingly have structure is put in place. If a small company presents audited accounts to a bank or prospective creditor, does the CEO bear responsibility for its accuracy? The code provisions appear to say no, but probably yes. Under extant criminal or civil laws, there is liability, of course. So I don't understand that provision in section 4051. Perhaps I'm misconstruing it. And if you also bear in mind that the definition of a small company allows annual revenues of 120 million, net assets of 60 million, that appears to be not so small. So I'm really very comforted by the Registrar General's comments that they would try through administrative measures to really put those companies within the realms of annual turnover of 25 million or so. So I think that is something that we may want to bear in mind. Obviously, there seems to be some bit of a shadow of revenue here, because of course, as you enable these companies formalize, then also there's the bringing them into the tax net is also assisted. I would like to stop there. So I see somebody says they don't agree with my views as far as independent directors, competency of independent directors. That's good. I think the issue, of course, is to open up the discussion to contrarian views so that it can be a bit more robust. But the point I was making is that the issue of independent directors has been studied all over the world. And basically two things that I mentioned, or three things that I mentioned is one, the issue of independence. Directors are actually supposed to be independent, even if they are nominee directors. Independent in terms of being loyal to the company and taking their decisions to favor the company. But of course, in commercial reality, that gets to be a bit difficult. If it gets to court, the director will be liable if it's obvious that he's not loyal to the company. So the issue of independence is there, but the issue of independent directors who are more like stakeholder directors is something else entirely. Well, he says regarding the competency of independent directors.
I think, Prof, I think it might be better we take the questions at the end of the session, because we have about 25 minutes for questions.
Okay, I will stop there, but I think it's also useful to interact with the how's it now, with the with participants as they raise issues in the chat. So let me stop at that point. Thank you very much.
Thank you very, very much, Professor Ajayi, for the interesting way you've touched on independent directors and a single owner question. Well, let me take it now to Aziza, where the question in terms of that one of the new provisions in this CAMA relate to financial assistance. That is assistance given by a company in relation to acquisition of its shares. To what extent do the amendments introduced under CAMA 2020 permit a private company to provide financial assistance for acquisition of its shares? And what are the limitations, if any, and do these amendments impact on corporate governance? And what is the impact of debt push down measures? Aziza, please.
Thank you very much. On financial assistance, like Mr. Gdali said, it's a bit of a welcome development, particularly from deal structuring perspective. And I'll try to answer all the questions together because they are a bit related. So CAMA now allows private companies to undertake financial assistance, and it provides caveats. It's tried to introduce the whitewash principle, which unfortunately was repealed in the UK, I think in 2008, and we're adopting it in 2020 in Nigeria. Now, it allows private companies to issue to give financial assistance for their acquisition of their shares or acquisition of shares in their holding company, but you need a special resolution. The directors are also to give a statutory declaration in a form to be prescribed by the Commission. The form itself is not prescribed in the law. So hopefully the format of that prescription or whatever the CSA will come up with will be such that will enhance proper disclosure and transparency. There's also the fact that when you give the financial assistance, it must be such that does not reduce your net assets. Well, if it's going to lead to a reduction in your net assets, then you should do it from your distributable reserves. So it has given private companies more leeway, additional leeway, but also kind of like reduced or curtailed to ensure governance. Because in the process of giving the declaration, which will be filed at CAC, expectation is that directors, particularly where the financial assistance has been given for the benefit of a majority shareholder, the minority shareholders, representatives on the board are able to look at the transaction holistically and determine whether or not the company can actually afford to give the financial assistance. So it doesn't necessarily impede corporate governance. I think it has put more, in terms of structuring, allow people to be more nimble, and then places additional responsibility in that nimbleness, because you won't be irresponsible in giving a statutory declaration that you've complied with the law. Now, in relation to debt push down measures, like I said, one major advantage of this new financial assistance is in terms of structuring acquisition transactions, leverage buyout, like Mr. Gdalo alluded to in his keynote address. Now, debt push down measures are transactions where I want to buy shares of a company. I set up an SPV, for example, and then I obtain an acquisition finance loan to buy the shares. Subsequently, I would like to merge the target with the acquisition vehicle. When I do that, the debt taken by that acquisition vehicle will go into the target company pursuant to the merger. It was always a bit of an issue before CAMA 2020, because the language then in 1990 CAMA was that you cannot render financial assistance where it will result in a material diminution in your net assets. The term material was not defined, which CAMA has now defined to be 50%, and has also defined what will constitute net assets. So it allows companies to now undertake debt debt push down measures. It allows companies to structure their acquisitions and acquisition finance transactions properly within the confines of the law, and they are more nimble. Now, there's a funny section there that says that directors can also, a company can also grant financial assistance where it is for a larger picture. I mean, so it's more subjective. It's not specific in terms of what that larger picture is. So once I see that, if, for example, I'm doing an acquisition and I want to give an indemnity, indemnity again was one of those things that when you negotiate a share subscription agreement, it's always an issue that how much indemnity can a company give that will not amount to financial assistance. So with the new amendments to CAMA, the new insertions in CAMA 2020, it appears that you can now give indemnity in your share subscription agreement, provided that it doesn't result in 50% or more than 50% diminution in your net assets. So from a governance perspective, I do not think that it impedes corporate governance in any way. I think it makes directors or management more nimble in structuring their deals, or they just have to be responsible in applying that section of the law.
Thank you very much, Aziza, for that interesting contribution. Let me just, based on what you've explained, let me take it back to Professor Ajayi again and ask, with regards to what we've just heard, are there any new provisions regarding the duties of directors, particularly as regards corporate sustainability? And what are the implications of this on corporate governance and the so-called environmental, social, and governance responsibilities? Professor Ajayi, please.
Thank you very much. There has been what looks like
We can't hear you, Prof.
Can you hear me?
No, we are hearing you now.
Hello?
We are hearing you.
You can't hear me.
We can hear you. We can hear you. We are hearing you, Prof.
Right, okay, I thought it was frozen. Right, so Section 279 of CAMA 2004 has been amended apparently in a minor detail by Section 3053. It empowers directors in exercising their duty to promote the company's business or the success of the company, to have regard to the impact of the company on the environment.
I think your voice is low again. We can't hear you very well.
Okay. My volume is at the highest. Right. Okay, I said section. Is it better now?
Yes, it's better now. Yes. Thank you.
Okay, thank you. Well, what I've said is that Section 3053 of CAMA 2020 amends Section 2793 of CAMA 2004 in apparently a minor degree, but in a progressive manner. It requires directors, or rather it empowers, I think that's the word that we should rather use. It empowers directors in exercising their duty to promote, the purposes of the company, the success of the company, to use the UK language, UK Companies Act language, to have regard to the impact of the company on the environment in the community where it carries out its business. Of course, in the UK, Section 172, the courts have held, and the balance of opinion, academic opinion, is that this provision really does not give, stakeholder rights. It does not create a duty an internal duty on corporate company directors to promote corporate sustainability. The argument is that really what it does is empowers directors to, so to say, set aside the interest of current shareholders in favor of maybe giving money, charitable activity to protect the environment or to promote stakeholder interest. This is still classical companies law. The idea being that when you promote stakeholders' interest, it will redound in greater benefits to shareholders. So it's not as if the philosophy has changed. Then, of course, you have the constituency statutes in the United States, which also suggests that directors can look to or promote stakeholder interest. But it's also been agreed in those jurisdictions that the constituency statutes are really an excuse or an alibi for directors to, give out money to stakeholder interests in the overall benefit of the company. The idea being that if a shareholder wanted to sue directors on the basis that they did so, this provision would be, how do you call it now, would be a defense to them. I've of course argued in an article somewhere that in the Indian Companies Act, and probably also in the Nigerian Companies Act, especially when we had the former FRC code, that actually this duty indirectly gives or imposes a duty of promoting corporate sustainability on directors. Because if the section says you may have regard to the environment and the community in which you, in which you operate, it means that your decisions at the board level ought to factor that consideration as into your decisions. Now, the question then would be, if you ignore those interests, would you not be hurting the company in terms of its reputational assets? And if that is so, could you be said to be acting as a fiduciary? So I think this will probably open up some impetus to directors to be more mindful of the environmental impacts, community impacts of companies. Now, we must bear in mind that the Principle 26 of the FRC code lays out more elaborate sustainability practices. So, of course, the idea is that when you add these principles to this section 3053, it's a movement in favor of director responsibility for corporate sustainability. The NSC sustainability guideline, at least for public companies, also speaks about ESG risks, environmental, social, and governance risks, and the need to report these. This is part of the sustainability reporting refresh that the NSC, the stock exchange, has brought in place. So when you look at the principles, FRC principles, the NSC sustainability guidelines, I think it would be possible to marry these along with section 3053 to require directors to be a lot more mindful about the impacts of the company on the environment, on the community. Looking through the act and the requirements that should be in the director's reports, I have not been able to see that there is some sustainability reporting required in CAMA as far as environmental duties or stakeholder duties, apart from employees and, of course, charitable giving. It's the same thing of as we had in CAMA 2004. So that is an area I think probably can be developed when the reviews of CAMA 2020 are being put in place. I end on this point. Can a director say that he will not have regard to the environmental impacts and say, well, the law is that companies will not second guess directors as far as their decisions are concerned, barring, any patent fraud or misbehavior. Because will you say you are a savvy director? Will you say you are you are competent if you of environmental liabilities, social and governance liabilities, sustainability, sustainable development goals? Will you say you are a competent director if you're not of where the world is going to, and you're not reflecting that at the board level? So I think this is probably an area where we may need to, with the evolution in company law in Europe, in Australia, and in other areas where a lot of effort is being made to sort of put legal responsibility, on companies to be more mindful of the impacts of their operations on the environment and communities.
Yes, thank you, sir. This is Aziza. Just to say that there's a section in CAMA, I'm trying to look for it, that seems to suggest that there are certain principles, they are not necessarily sustainability principles that companies are supposed to comply with, but it doesn't even specify. So we are hoping that the CAC, in coming out with regulations, will specify what those sustainability principles or what the guidance will be for companies, because there is a section that I'll find it before the end of the program and highlight it, that seems to suggest that those principles are there, that those principles are supposed to be complied with, but the principles themselves are not specified in the law. So again, there's a gap, because for PLCs that are listed, they have the NSE to guide them. For private companies that are not listed, that obviously not listed, or for public unlisted companies, where is the guidance in terms of sustainability? So like I said, the financial assistants, hopefully directors, because of additional disclosure obligation, because people are getting more savvy, because they need to disclose, will be responsible in implementing the financial assistance, or in taking benefit of the financial assistance provisions that we now have in the new CAMA.
Yeah, thank you very much.
Thank you very much, Aziza. Let me just make an appeal. It's raining, and it's a bit difficult to hear what our panel members are saying, but let me just appeal that if they can really increase their voice so that we can all hear them very, very well. But on that note, let me go back to Olumide with regards to issue of general meetings. And the question is, what changes were introduced by CAMA 2020 as it relates to holding of general meetings, the business to be conducted at such meetings, form of issuance of notices of meetings, and how the chairman's casting votes as contained in the Repeal Act is now to be treated in the new law. Could you discuss how these improvements will impact on corporate governance? Olumide.
Thank you, Franklin. So with respect to general meetings, I guess the first thing that comes to mind is the fact that small companies and one shareholder companies are now exempted from holding general meetings. Secondly is the fact that you now have an additional business that's been added to the list of ordinary business that are to be conducted at a general meeting. Before the ordinary business is just includes laying the consideration of the financial statement with the auditor's report and director's report, declaration of dividend, appointment of or re-election of directors or resigning by rotation, the appointment of auditor, external auditor, and fixing the remuneration, as well as election of statutory audit committee members. But now the law has now provided that disclosure of the remuneration of managers should now also be part of the activities at the general meeting, and at an annual general meeting. And unfortunately, the law did not define who a manager or who the managers are. And then the question will then be, so how do you define who will be caught with that? Will it just be executive directors, or will it be the senior management level, or whoever? There is already a similar, so there's a similar provision under the IFRS Rule 24, which requires the disclosure of remuneration of key management personnel in the financial statement. And that law and that rule define key management personnel as those people having authority and responsibility for planning, directing, and controlling the activities of the entity, directly or indirectly, through including any directors. So the question would then be, so question number one would be definition of directors, of managers. And then question number two will then be that if my financial statement already complies with this requirement, will I be deemed to have complied with this new requirement by the law? Or is it that I then need to then specifically prepare a disclosure document that will then discuss as an agenda, as part of the business of the general meeting? I think it's an issue that the CAC needs to provide clarification on. But I would say that it's a welcome development in that it then gives more disclosure for the shareholders. If you recall that one of the key issues of corporate governance is addressing agency costs, where you don't want a situation where the managers of the business are spending an inordinate amount of money on themselves compared to the amount spent on the business.
Olumide, please, can you raise your voice more, please?
Okay. All right. Okay, so I was saying that if you understand the fact that corporate governance, one of the issues that corporate governance seeks to address is the issue of agency costs, where managers of the company are spending more money on themselves compared to what the business is earning or what the business requires, then you understand that the requirement for the disclosure, it's a good thing, and then puts the managers right in the view of the shareholders, necessary disclosure to ensure that their spendings on themselves is not inordinate compared to what the business requires. Another introduction with respect to general meeting is introduction of electronic meeting or virtual meeting. But unfortunately, this is restricted to private companies and not public companies. This could be attributed to the fact that by the time so in any case, no excuse, is that it was not considered necessary. I thought that I believe the time that this bill was passed, people did not consider that there would be a time when it would be possible for general meetings of public companies to be held virtually. Now that technology has ramped up to make that possible, it becomes an issue, and we hope that CAC will be able to deal with this. So we know that CAC has provided guidelines. So the issue will then be whether the language of the law allows CAC to then bring the guideline that he had issued prior to the during the COVID era and prior to the passing of the law within the framework of the law to ensure that there's continuity. But the law now allows private companies to hold electronic meetings in accordance with their articles. So it may be necessary for them to then put necessary provisions in the articles that not only enables but also guides them in what they do. Another development is the issue of venue for general meeting. Small companies and one shareholder companies are no longer restricted to having. So the general rule is that general meetings must be held in Nigeria. But the new law now, Section 241, now excludes small companies and one shareholder companies. There's issue of notice of general meetings as well. Number one is the fact that for public companies, the law now requires that CAC is now entitled to receive notice of general meetings of public companies. Before, that wasn't the case. It's just directors, debenture holders, auditors that are allowed to, and shareholders that are allowed to, that are entitled to notices. Now it includes the CAC. And I suppose that, I guess that it may be necessary to maybe possibly include an omnibus clause that would then allow for, or should I say, take into consideration the fact that certain regulatory agencies require to be at the AGM of the regulated entities. This is particularly the case with respect to entities that are regulated by the CBN. Also, there's now service of notice by email is allowed, but the language makes it a little bit tricky, because the language of the law now says that in addition to service of notice by personally and by mail. So that means that you cannot not yet serve notice by email alone. An attempt has to have been made to have been served the normal physical way. And then in addition to that, notice will then be issued by email. And then that will then serve so that we would then not run the risk of having the meeting voided for failure to give notice. So essentially the implication of this for corporate governance is that number one, for public companies, there is more effective oversight. Notices can be given efficiently and effectively. I will also echo what Mr. Godalo has said with respect to the small companies, that there's a need to ensure that this, maybe the issue will then be that, yes, the exemption is welcome, but for small companies and one shareholder companies who intend to approach to raise fund in the future, to raise capital in the future, it's necessary for them to take the conscious step of adopting some of these corporate governance requirements to ensure that they then begin to put in place necessary processes as well as necessary processes and necessary disclosure requirements to ensure that they have the documentation processes that makes them attractive for investors. Thank you. Franklin.
Thank you very, very much, Olumide, for that interesting contribution. As I said, it's raining heavily where I am, and a few people have called me or sent me messages that it's also raining in the areas where they are in Lagos. So I will still appeal to the panel members to please and please and please increase your voice. We are hoping that the rain will soon stop. So, but in the meantime, if you can increase your voice so that people can hear you, that would be highly, highly, highly appreciated. So let me take the question back to Aziza, then I will come back to Professor Jai. But Aziza, I want you to look at the issue of distributable profits. And the question is, are there any legal intricacies around the new provisions which relate to distributable profits, especially in circumstances where companies are undertaking company restructuring? How would these legal intricacies be dealt with? And would these provisions have an effect on corporate governance? Aziza, please. And as I said before, it will be appreciated if you can increase your voice to the highest and highest and highest volume. Thank you.
Okay, is it loud enough?
If you can try more, that would be very good.
Okay, I'm going to really try.
There is a competition on anybody that increases his voice very well, we get a prize.
No, I don't think I'll win that. So I won't even try to compete. I mean, so the first thing I'd like to say before I go into the question is to Prof that I've seen the section is on the sustainability principle in the new CAMA, is section 305 subsection 3. So in the new law, after circumstance, there's a new clause that says that, and in preserving the assets and assets of the company, the director shall have regard to the impact of the company's operations on the environment in the community where it carries on business operations. So the new CAMA tried to introduce some sustainability principle without guidelines, which we hope the CSC will then reach.
Yes, that was what I was actually dilating on that section 305.3.
Okay, yeah. Okay. So back to my question on the distributable profit. So I really do not think that the new additions are major legal intricacies. I believe they are more accounting and should enhance corporate governance, because what you have in CAMA now is that in distributing your profit or in declaring dividends, you need to take recognition of accumulated losses. So it defines distributable profit as your accumulated profits, less accumulated losses. So the situation where a company keeps paying dividends because it made profit in a particular year, but it has accumulated losses for the previous year, should cease with this new provision, because you will not, the profit only becomes distributable after you have taken care of your accumulated losses, or you have written them off using a capital reduction. So one, I don't think that it should impede corporate governance. I think it should make directors and management more accountable, because you cannot declare dividends until you do with accumulated losses. Shareholders will ask you, oh, but you made XYZ profits this year. Why are you not declaring dividends? So people will work towards reducing accumulated losses as much as possible. And it also avoids a situation where you just have this rosy forecast or rosy profits statement without necessarily recognizing your accumulated losses, particularly where it's a new investment or something has happened. As we saw in the banking era at the time, most of the banks that had issues had a lot of accumulated losses. I also think that the section as we have it now will legalize or formalize what had been happening before now, where companies do capital restructuring and they do a reduction where they write off their losses unrepresented by assets with monies in their share premium account. There has been the debate over time as to the legality or otherwise of this process. But the new CAMA recognizes that you could actually write off your losses by doing a reduction of capital, because if you have assets that are not represented by capital, then you should reduce your capital in such a way that your balance sheet is real and you're not keeping assets that you have so much liabilities, and you get to a point where you keep accumulating losses. You've been declaring dividends, but over time, the losses you make will now make your liabilities way more than your assets, and you are heading for bankruptcy. So from a governance perspective, I think that it should enhance corporate governance, it should enhance accountability. And it's also similar, the section is similar to what you have in a number of jurisdictions where before you declare dividends, you need to take care of your accumulated losses. So I don't see it as a challenge. I see it as one of those new introductions to CAMA that should help our companies, directors and management, be more accountable and be more transparent prior to declaring dividends.
Okay, thank you very much, Aziza, for that contribution. Let me take this back to Professor Ajay with regards to issue of directors or corporate governance in general. Remember that earlier on there was a question, or there was a kind of a bit of disagreement with your views on independent non-executive directors. So I would like you to touch on it briefly, but also what other aspects or perspectives of the law as related to the directors or corporate governance in general do you think are worth mentioning or ventilating for our participants? Thank you, Prof.
Thank you very much. I will come back to the issue of distributable profit, but let me immediately answer your question. There was a comment by, I don't know if it is the illustrious former governor of Lagos State, but the name was Bola Tinubu. And if it's the governor, we are, of course, very delighted to have you in place.
Can you increase your voice, Prof, please?
Oh, okay. Well, I had forgotten there's a prize for shouting, but
exactly.
I would not be able to shout, but I will try to project my voice. Yes, there was an apparent disagreement, and the comment was by, it said Bola Tinubu, and I'm saying I hope that is the former governor of Lagos State, and if so, it's a real honor and pleasure to have you here. The point, I think, of disagreement was related to my comments that there is no guarantee that independent directors will necessarily be versed in the industry or sector of the company. And there may be issues also as to their exposure. And his comment was that he doesn't really agree because he expects executive directors or directors to select the proper persons, competent persons as independent directors. Yes, so my comments really are admonitory. So the idea really is that let's be careful to ensure that we are putting in place safeguards. I may say that it's a major issue of corporate governance in companies, perhaps also in Nigeria, to select the right persons. You need a particular level of culture to do that. Otherwise, let's be fair, most boards or most executive directors would probably prefer to have an accord concordial, if I could use that phrase, in terms of the directors. They would prefer not to have people who will be breathing down their necks. That's the human instinct. The expectation and hope, however, is that boards of directors will be open to the necessity to ensure that they submit themselves to oversight and, make themselves available to those who are going to ask tough questions and not necessarily be, what's the word, antagonistic. A board meeting is not really the place to have a civil society activist. Even the tone, the language, it doesn't go that way. So the idea really, of course, is hopefully this type of selection will be done. But merely having those provisions in the Act does not mean they will automatically be embraced. So the idea is that hopefully they will be embraced. But my point was, of course, that loading the board with independent directors may not necessarily improve the quality of corporate governance. At a point, it may in fact even diminish the quality of corporate governance. But these are philosophical issues and issues of practice and institutional context, so that we're not just drafting laws because we borrowed from somewhere, but we look also at what is happening in our society what is the practice, and what are our objectives. So I think that's the point that I was making. But I very much agree with Mr. Ighodalo that 3 is somewhat on the high side, because that suggests that you're going to have to load the board. Now, don't let's forget, of course, that as far as corporate governance is concerned, shareholder oversight is also historically a very important aspect of oversight. But in public companies where you have atomization of shares, then it looks like we're going to now have this tribe of independent directors who will, probably be the ones giving voice to those smaller shareholders who cannot find a place on the board because those with concentrated minority shareholdings have packed the board. So I guess those are the dynamics that are in place. So I think there's also need to sort of do, is it a school for independent directors, or in terms of our institutions, we also need to be ensuring that there's some, preparation for independent directors, there's some oversight for independent directors. So I think that's the point I'm making. Yeah, I can see in the chat that Bola Tinubu is a partner of Olajide Oyewole. It's not the Bola Tinubu. Well, that's interesting. So that's the point I was making. Now, the issue of distributable profits. There obviously Section 427 of CAMA 2020 appears to be an improvement on CAMA 2004 in requiring that profits should be paid out of accumulated realized profits, less accumulated realized losses, because this suggests that the essence is not to pay dividends out, to pay profits. And I think that's an improvement. The more directors are forced to ensure that there are economic returns, not just accounting returns, I think that really would increase the level of how do I call it now? The level of care in ensuring that opportunity cost of capital is very judiciously utilized. I also noticed that there is section 4293, which says where dividends have been sent to members and there is omission to send to some members due to the fault of the company, the dividends shall earn interest at the current bank rate from 3 months after the date on which they ought to have been posted. That is help.
Thank you very much, Prof.
Yeah, sorry, just two additional comments on what Prof was saying around that posting.
The unclaimed dividends is not actually backed by CAMA 2020. The SEC has always been saying, oh, these unclaimed dividends are so huge, they should be put into some trust fund and used for some purpose or the other. But as a company secretary, the truth of what I always felt was these funds are, the unclaimed dividends are dividends of shareholders. And even if shareholders have forgone those because they haven't come for them in due course, it's good for business that, the companies can put those unclaimed funds in, not necessarily in working capital, but for the benefit of shareholders. So I've never really supported this idea of SEC trying to, put its hand on unclaimed dividends. And I'm really quite gratified that CAMA 2020 has not gone in that direction. It's tough running a business in Nigeria. There's no point putting unclaimed dividends in some fund, in some commission and then those monies will not, will not be treated with accountability, whilst companies who could use them, because these are monies of their shareholders who are still on the books, are sort of shut out. I think those are some of the other areas that we may want to look at. Multiple directorships. This issue of limiting the number to 5, to me, it looks like it's a red herring. Why not 3? Why not 10? It's an arbitrary figure. Yeah, you say the thinking is that directors can limit themselves. And I heard Mr. Godalo saying the needs of proper oversight are so huge. Yes, that is true. But the truth of the matter also is that, non-executive directors are not expected to be, so to say, reporting to the company every day, and must gain the competence to be oversight, to provide oversight, not get involved in the day-to-day running of the company. And this is an area where I think in our companies, there are still issues, not only even in companies, but across board. We see that also in public governance. So as to me, I think this is a red herring. Then finally, audit committees. I think my colleague has spoken that there's a progress here, because you have 3 members from three members of the audit committee from the members of the company and 2 non-executive directors. I think this is better than what we had in CAMA 2020. The other thing, of course, is the audit committees now, the section 445 says all the 5 members shall be financially literate and 1 shall be a chartered accountant. This is in line with FRC code principles and the other code of governance principles. So I think these are useful provisions. The idea, of course, is that the Act is statutory law. The code will help the tone of corporate governance, and that is really what attracts investment. And this is something that we must take very seriously. If it is out there that the tone of corporate governance in Nigerian companies is sound, then investors feel more confident to bring their monies into our country. So this is certainly something that we must take very seriously. The IOD and various other bodies, the capital market, must work very hard in ensuring that we get there. Private companies also no longer have chairman and CEO. These are all in the right direction. I think I will stop there. Thank you.
Okay, thank you very much, Prof, for the way you've explained the issue of INED and other contributions you've made. We are running against time because we want to open it up for questions. So I will please appeal to, I will ask 2 more questions, one to Olumide and then one to Aziza before we now open it up for questions. So I will appreciate if we can make it very brief. And this relates to, of course, as we are talking shortly, we are told that the issue of confidential information is also a big issue with regards to this CAMA. So the CAMA 2020 has introduced additional liabilities for directors, treatment of certain confidential information relating to directors, and this protection of directors from holding a directorship position in other companies. Olumide, could you please shed more light on these new provisions and also highlight the new disclosure obligations introduced by CAMA 2020 to strengthen corporate governance? When Prof was talking, Prof said that maybe Bola Tinubu is the former governor of Lagos State. But Mohammed Dauda immediately practiced full disclosure and told us that she's a partner in Olajido Oyewole DLP. So please, can you tell us the disclosure obligations introduced by this new CAMA to strengthen corporate governance, particularly with regards to issues of director position and confidential information, please. But quickly, please, Alumni.
All right. Okay. So, so essentially, with respect to liability, what has happened is the law has now increased instances where directors.
I'm not sure we are hearing Olumide. Can we all hear Olumide, please? I cannot hear him.
No, I think he's having internet network issues.
Okay. As he's having network issue, let me just quickly, Aziza, if you can help us to look into the issue of share buyback. I mean, it has been clarified through the removal of limitations to the implementation of share buyback. Could you please elaborate on the limitations which were removed? And if this, can you hear me, Aziza?
Yes, I can. Yes, I can.
Yes. And if this will have any effect on how a company is run, please also highlight any inconsistency, if any, with provisions of SEC and NSE rules in relation to the threshold for share repurchase. Thank you. Quickly, please.
Yes, I'll do that quickly, but also quickly, just to clarify that on the dividend, what the SEC, with the point Prof had made regarding unclaimed dividends, what the SEC rule had provided for was that company retains 90% and then the registrar should keep 10% as agent of the company. The SEC rule provided that the companies can invest it outside the company and cannot invest it otherwise as provided for in CAMA. Unfortunately, what the new CAMA has done is just to reproduce the provisions of the SEC rule to say that the monies can be invested outside the company and not for its purpose. And then after 12 years, the money should go back to distributable profit for redistribution to the shareholders. So that's what CAMA 2020 has done. It reproduced the section of the provisions of the SEC rule and then added the fact that the money should go to distributable profit. Now, to the question on share buyback, yes, the restrictions on share buyback have significantly been reduced in terms of under the old CAMA, you could only do share buyback to buy out the dissenting shareholder, or if you have an agreement, you had an agreement to buy back the shares of the company or to settle or compromise a debt or pursuant to a court order. That pursuant to a court order was a very, it was an interesting provision that was not really interpreted or enforced until this year by the courts, where we had a client that relied on that provision to get an order. So now what you have now is that those restrictions have been removed, provided you follow the procedure set out in CAMA, which deals with how the shares can be bought and where the shares can be, where the buyback consideration should come from. Now, I think this should come as a relief to a number of public companies who have a lot of shares listed on the Nigerian Stock Exchange. And because of the volatility in the price of those shares, it doesn't necessarily reflect the value of the companies, which was why a lot of public companies wanted to do share buyback then, but the restrictions in the law did not permit them. So hopefully they will make use of this because those restrictions have been removed. Although there's a caveat that allows a creditor to challenge your special resolution within, I think, 6 months from publication of that notice. A creditor or a dissenting shareholder can go to court and refrain you from doing your share buyback. So the restrictions are no longer there. In terms of the inconsistency, I mean, two major inconsistencies. The CAMA seems to suggest that you could actually buy more than 15%, and then it gives you a grace period to sell down to 15%. Whereas the language of the SEC rule and the NSE rule is that you cannot buy back more than 15%. Now, CAMA is a statute, and SEC rule and NSE rule are regulations, they're subsidiary legislation. So the assumption from a speak legal perspective is that the provisions of CAMA will prevail over the SEC rule and the NSE rule, where a public company decides to embark on a share buyback. Now, again, CAMA, the new CAMA seems to suggest that those shares that are bought back are now technically, they are now properly defined as treasury shares, which was a term that was not really known in our law before. We had it referred to in a schedule in the old CAMA without a definition. So the concept of treasury shares has now been formally recognized, and CAMA provides that you can reissue those shares. SEC rule and NSE rule seems to suggest that you must cancel those shares. Now, CAMA has allowed you to hold those shares, but has provided restriction on what you can do with those shares. So the company cannot vote on those shares, for example, until those shares are reissued, which I really think the SEC and NSE rule should also have provided for, instead of asking companies to cancel those shares when they are bought. So again, the assumption is that CAMA will prevail, and when companies do embark on share buyback, one, they can buy more than 15%, but ensure that they scale down to 15% within the grace period provided for in CAMA. Again, it will allow directors more option, because we've been talking about disclosure, we're talking about more accountability, but there's little nimbleness. Now, there's also additional nimbleness, and directors can take a view as to where share price is going, the impact on that on the value of the company, particularly when you start calculating the earnings per share, and decide to embark on the share buyback. So it's a welcome development, and hopefully will be utilized by directors of public companies in particular.
Thank you very much, Aziza. I'm not sure if Olumide is back. Olumide, are you back, or are you still having?
Back.
Okay, you are back.
Apologies, internet glitch.
Excellent, that's fine. Okay, just using 2 minutes, please, because of time, and questions have already come with regards to what I'm going to ask you now.
Okay.
What do you think? Of course, you know the controversy with regards to the issues of church and other organizations. So the question is, what do you think will be the effect of the new provision which relate to incorporated trustees? Will such new provision impact on how such associations are run? Or will you term it a welcome development or unnecessary, in view of the fact that government does not contribute any money in running such establishments? Quickly, please.
It is definitely a welcome development. It's an improvement on the previous situation where associations, non-profits are left, particularly associations organized as incorporated trustees, are left totally to themselves, unregulated. The provisions provide so essentially, it's not as if some of these powers that are now codified are functions that CAC has been performing before. People would write petition to them. They would try to then mediate and see what is going on. Now they now have the power of the law to actually step in and make sure that things are done in a sane manner. So this is the argument that I give to people. I say that, look, you have the opportunity to continue to exist as an incorporated entity. But if you must choose to exist as an incorporated entity under the law, then there are certain duties and responsibilities you owe to government. And so you must need to choose. And that's the situation. Government needs to regulate your activities. You cannot say that they do not contribute to the money. If you must enjoy the privileges under the law, then you must enjoy you must also carry the responsibilities and obligations under the law. And that obligation include doing things in a proper manner. Corporate governance must apply both in non-profit and for-profit entities. And these provisions are designed to ensure that corporate governance is enshrined, that managers are accountable both to the association and to the law. The issue will be, for instance, my concern will be in the appointment of the interim managers. There should be some guideline to address the issue of trust that Mr. Ighodalo has highlighted. And the concern that will also come up is that, look, who will the interim manager be? There is the issue of bringing an outsider to come and manage the affairs of a closed group, which will not be acceptable to the members of the association. There's also the issue of, do you then bring people in the association who are subject to the control and influence of the trustees that have been suspended? Then that means the same system still continues. Where there's a need to conduct investigation into alleged frauds or crime, if you put the same people there, people under the control of people that you have suspended, will they allow for effective investigation? So these are the issues that come up. There's the issue of, there's also the provision for the transfer of credit in a dormant account. That will also, I'm surprised that people are not even making noise about that, but they're making noise about the issue of suspension of trustees. I would have thought that the issue would then be, what would warrant the number one, breach of confidence, that the law now mandates courts to then disclose to CAC that I have money with them in an account that is dormant. That should, I would have thought that would have been a bigger issue. And then why would then the CAC have the power to then give direction that the money that belongs to the association, though in a dormant account, should then be transferred to one way or the other to other association? But the justification for that will probably be that, look, you are supposed to have been established to promote certain causes. Now, your assets, your funds are supposed to be used to pursue the promotion of those causes. And if you then have funds that are not being used, then it would then mean that either that you are no longer in operation or something. And if you see the way the law is couched, the provision says that the CAC receives information about the dormant account. CAC sends notice to the association saying that, look, explain your activities. And if 15 days after the receipt of that notice, you have not responded to give clarification about your activities, that is when that order can then be made. So it all goes to the issue that we want associations who, if you are enjoying privileges under the law, we need to hold you to the things that you say you are doing. And so it's a welcome development. The issue will then be, we need to then look into the guidelines that will guide CAC in the performance, in the exercise of these powers. Of course, the law gave some guidance. So, for instance, with respect to the direction regarding a credit in dormant account, it says the power will not be exercised without the approval of the minister. But it's important that there should be guidelines saying what shall be done, what should not be done. Another interesting thing that I also saw is that there appears to be conflict in the definition of dormancy. When is an account stated to be dormant? The provision of the law in one provision says that dormant in accordance with the regulation of the bank. Then it then goes in another provision to then list out that it will be considered to be dormant where transactions that has occurred in that on that account does not include no transaction has occurred on that account other than deposits and transactions originated or effected by the bank holding the account. So there needs to be clarity. Are we staying with CBN or are we staying with CAC when we want to define dormancy? But all in all, I think it's a welcome development. I think it will make our association stronger, better managed, and there's better disclosure. Thank you.
Thank you very, very much, Olumide, for that interesting. You know, I told you to make it very brief, but as you know, lawyers like talking and talking and talking too much. The only thing I heard from Olumide, which I took out, is that he is saying that it might be good for our tithes and contributions to be properly put under proper corporate governance. So if you're giving your tithes, just be sure that it will be under proper corporate governance. So based on that— I
want my pastor to chase me out of church on Sunday.
So that what it means that we can actually contribute more tithes now because we know that it will be under proper corporate governance based on this new CAMA. But using that, somebody is asking a question. Uche is asking us a question. So it's open for questions now, and we'll take a few questions. So Uche is asking, what classifies a company as small? And I would like Professor Olawale Ajayi to answer that question. What really, when you say the company is a small company, and even a single shareholder company, what does it really mean? Prof, please.
Yes, I think the threshold is annual revenues of 120 million and net assets of 60 million. That is the parameter for determining what is a small company in CAMA. May I just very quickly piggyback on Olumide's, and the issues are, I think, probably a bit more nuanced, which is why I said earlier on that we must be context driven. I think the noise is coming from the religious sector. And we know what the sensitivities are in the country. So I think in discussing these issues, we must be sensitive to those issues and not just take them and say, because in the UK it happens, therefore it's perfectly okay. I think that should be the way to look at this. There's a feeling that can work injury to the constitutional freedom of worship. And I think those issues should not just be washed away. Of course, it's necessary for bodies that subject themselves to registration to practice good governance. And I think that cannot be or should not be, underemphasized. But those nuances are there, and I think it will be very useful that in discussing this, let the tone go down and let's be a bit more careful. Can you imagine what it would mean if you ask a pastor to go and be appointed to go and look at the affairs of the other faith, or vice versa, or vice versa? So those are sensitivities we need to be careful of. And I think probably, I'm just thinking off the top of my head, what do we do? Do we need to innovate in this regard, rather than just say we're importing what is best practice? You don't import institutions. They are not always readily importable without adaptation. So I think that's what I'd like to say as far as that is concerned. So maybe I can just stop there.
Okay, thank you very much, Professor.
I disagree.
I think that what you're saying, or maybe if I understood you well, is that even though on the face of it, that the act is good with regards to incorporated trustees, but we should take into consideration our socio-cultural and religious peculiarities, and how some of these factors can be used or can be misused in the face of some of the realities that we face in Nigeria. So of course, anytime we are adopting a law, it's very important that we take into consideration our peculiarities, in the sense that, of course, formal laws are normally from the norms and values of a society. When we document it, it becomes a formal law. If we don't document it, it becomes informal law. So that point is well taken. The next question says, from the provisions of Section 240 of CAMA 2020, it will appear that only private companies can hold their AGM electronically, as long as same has been provided for in their articles of association. He said, why is this same window not open to public companies? Aziza, can you take this question, please? And this question is from Collins Okamedre.
Yes, I mean, unfortunately, like Olumide had said that Mr. Agbalo also alluded to, for some reason, the provision of the law seems to focus on private company. I guess either the drafters were concerned that it may be a bit unwieldy for public companies to hold meetings virtually, but I don't think that is necessarily accurate. I think we've all seen during COVID, people have held AGMs, people have held court-ordered meetings virtually, and they've had participation in one way or the other. So I don't know why that section was drafted in such a restricted manner, but yes, it is restricted to private companies.
Okay.
I think the philosophy is that of accountability. And I think in the pre-COVID world, the idea is that you do not want to sort of shut out, how's it now, shareholders from being able to attend meetings, even though we know that it's only a fraction for the public companies anyway. It's only a fraction who turn up physically. And even of those who turn up physically, it's probably more the case, unfortunately, in Nigeria, people are more interested in corporate gifts than in some of the nitty-gritty. Thank God for our shareholders associations, which is a welcome innovation we have in Nigeria. I don't think there's any recognition of shareholders associations in CAMA, even though the principles, the codes recognize them. So I think that's the issue, but obviously, probably that's an oversight. I guess the other point, of course, is that electronic meetings also have to be used advisedly. If, as we increase access, that is with digital access, then obviously it becomes more democratic. So I think probably that may have been the thinking.
Yeah, but I think they could have done it in a way that there's flexibility, so that once my articles permit me, the same way public companies are able to issue annual reports electronically for the people with email addresses, then I should have the flexibility. I don't have to travel to attend a meeting if I can participate virtually, and the law recognizes that.
So for me,
I agree. Yeah, okay, sorry.
I was going to say, so for me, if you will recall that the NSC also issued a circular with respect to electronic meeting for quoted companies. And I think that circular addressed the issues that would usually come up with respect to electronic meeting, which was essentially revolves around participation by stakeholders and how whatever structure that, whatever means and mode and structure that is adopted should ensure proper accountability, participation, and freedom of expression, so that stakeholders do not feel shut out or deprived of the opportunity to contribute in the meeting. And I think that, I guess that was the issue that must have been on the mind of the framers of the law when it was initially drafted. But like I said, it's obvious that technology has ramped up to ensure that these issues are addressed. And in any case, I think we can also put the principle, if we put the principle there that you can meet, but your meeting should ensure qualitative participation by relevant members, and guideline is provided to that in that regard, this issue will be addressed. So the question really will be whether the language is correct, and I don't think so. But we need to see whether CAC in the exercise of regulation issuance powers can actually supplement this provision to enable public companies to meet. That will be the issue.
Okay, thank you very much for the contributions. The last question before we go on break, but let me say something. I have a breaking news with regards to this CAMA, which relates to some of the issues that we are discussing now. And it's a very interesting news, which I'm sure will be good to everybody. But I will announce it when we come back after our break. So, but let me, before we go for that break, there's a question that says, private companies can hold their meetings electronically, but can only send the notices electronically after first sending out a hard copy notice. Is that the case? Olumide, quickly, please.
Sorry, can what?
The question is just a clarification. Private companies can hold their meetings electronically, but can only send the notices electronically after first sending out a hard copy notice. Is that the case? Or will sending out just electronic notice, would that suffice? Would that be enough to hold the meeting? Or do they still require to send out a hard copy notice first? With just 1 minute, please.
I confirm that by language of the law, they will have to, because Section 2443 of the law says that in addition to the notice given personally or by post, notice may also be given by electronic mail to any member who has provided the company an electronic mail address. So it is in addition. So it is so post, personal or post must be given first, then email thereafter. So that's the way it works. And in any case, so there is also this argument about whether the law is in effect or not. By the language of the Interpretation Act, CAMA 2020 is in effect. So, and so the issue of gazetting is simply for authentication. So that would then mean that, so we understand that there are some provisions that CAC will need to prepare itself for in order to implement, but those ones that do not have timeline for commencement or do not require the arrangement, compliance enforcement or certain administrative restructuring by CAC, we need to start implementing those.
Okay, thank you very much. Let me, just one question before we go, please. And Professor Jai, if you can just answer it in 1 minute, please, because of time. Can you clarify the issue, the confusion with regards to manager and director? Which one are we using and which one are we referring? Professor Jai, please, unmute yourself.
Yes, sorry, I said I'm not quite sure what the issue is here. Which section is this?
With regards to issue
additional, okay, sorry, I was going to say with respect to the additional business for the AGM, where the law now says that there must be disclosure of managers' remuneration at the AGM.
Oh, okay. I think this is basically directors, but don't forget that there's also supposed to be a table of remuneration of in the entire company. So I think executive directors are the ones in view here.
Okay, so basically what you're saying that even though they use managers, but in most, it might be applying more to managers that have grown or that are now executive directors of the company, as well as the other directors of the company. Olumide, will you agree with that viewpoint?
I'll probably use the term key management personnel, which will address the senior management team. So it's not just the EDs alone, but will include possibly the next line, who are the ones that makes the key decisions in the company. You want to know how much they are making for two reasons. One, to ensure that they are properly remunerated for the kind of service they are rendering, and two, to ensure that like I said, funds are not being dissipated on the management rather than in the business.
Okay, thank you very much, Olumide.
Sorry, I guess maybe it would be helpful for CAC in coming up with regulations to actually define who manager, what would be the criteria for saying somebody is a manager? Because sometimes in a lot of organizations, some of these terms are used loosely, yes, right? And that person may not be empowered in such a way that he's really a manager in the real sense of it, may not even be taking decisions, may not be responsible for anything strategic, right? So like a sales manager is used loosely a lot in the FMCG industry. So I think it will be helpful, maybe in coming up with regulations to guide companies on what cadre will constitute managers before you start disclosing everybody that you call manager in your organization, even if that person is not a manager in real life.
Even currently, not only do you provide remuneration of directors, it's also usual to provide remuneration of bands of managers in the accounts. So that is something that CAMA 2004, under CAMA 2004, was also the practice for public companies.
Yeah, but
Okay.
so companies will just have senior management generally, not managers. They just refer to them as senior management, and then they disclose their remuneration in their account. But the word manager is very fluid and can be interpreted subjectively sometimes.
Yeah, so definitely CAC needs to come up with a definition.
Clarification.
Yes.
Okay, thank you very, very much, our panel members, our participants. Because of time and health guidelines, we'll be sitting down for some time. And they said it might be time for us to just have 5-minute break or 5-10-minute break. So the time now is 11:50. So we get back at 12 o'clock, or let's say 11:59. So we can take off, or let me say 11:58. So we can use 2 minutes to settle down. But as I said earlier on, there is a very, very good breaking news, which I will announce when we come back. And I'm sure many of us will be very happy to hear that breaking news. So but hold on until we come back and you will hear the breaking news. It is very good and it relates to CAMA. So thank you very much. And let's take just a 8 minutes break and come back at 11:58. Thank you and good morning.
To Lagos Business School, you join the community that's made up of not only the staff and employees of Lagos Business School, but everybody who has participated in any program at the Lagos Business School. Our mission is to develop responsible managers for Africa and the world at large. And indeed, the first chief executive program participants of Lagos Business School coined the term the oasis of sanity to describe Lagos Business School. And therefore, as part of the community of Lagos Business School, we expect that every member of that community will be focused and committed to ensuring that we develop professional managers for Africa and also that we influence society. And how do we go about influencing society? By all the things that I hope that you have learned or that have been strengthened by your time at Lagos Business School. When you attend any of the programs at Lagos Business School, we make bold to say that in terms of the content, you will get the same as you get in any world-class business school in the world. And we make that promise because we have attained international accreditations from the 2 topmost accrediting bodies in the world. And we will only get that accreditation if they believe that the quality that we offer is the same as offered in top business schools of the world. But where we're different is that we talk about the peculiarities of doing business in Nigeria and Africa.
For us at BNI, it's beyond legal representation. It's about partnerships, collaborations, growth, business. It's about values, numbers, and ultimately national and international impact.
The vision behind BNI was simply to build, create, and sustain the best law firm, at least in Africa, that we compare with any law firm anywhere in the world.
It's been an interesting journey. It's been rewarding in the sense that we're approaching maybe the first level of where we wanted to be the best law firm in Nigeria.
And to sustain it, we have to keep improving, getting better, bringing in technology, is moving in certain directions, But the work we do, it must be technology married with people. For me, it's always about people.
B&I is a first-class law firm with over 28 years of excellent service delivery. Consistently ranked as a leading first-tier law firm in core 5 practice areas. intellectual property and technology, which includes our media and entertainment law practice, litigation, arbitration, and alternative dispute resolution, energy and natural resources, which houses its oil, gas, power and mining practice areas, shipping, aviation, and international trade, and corporate securities and finance, wherein sits its M&A practice as well as its project finance and private equity practice areas.
We hope that, first of all, you'll have a very nice and pleasant time with us, and you'll come away with something that you'll find useful for your own endeavor, for your own business, for your own enterprise. Welcome to Bangwa Nigudalo.
The significance of the LBS Talent Forum is actually to help companies identify the talent that they need for Africa and for Nigeria. One of the high points is really having the CEOs of some of these respective companies dialogue firsthand with some of the talent that we have, and also discuss issues of topical interest that will help shape how Nigeria's economy improves over time.
There's no organization in the world that can grow without talent. The need to seek new talent is perpetual. So we're naturally looking for people that possess the skill set required to solve today's problem and provide solutions to tomorrow's problem today.
I think it's been very insightful. A lot of research has gone into all the various presentations that were done today, and we would expect that, taken from the learnings of today, they would go back and actually activate and actualize this, and also be part of the change agent for our economy.
I'm looking for people who are creative, innovative, who don't mind to get their hands dirty. Our job may seem glamorous, but we need people to be very hands-on and people who have an entrepreneurial spirit.
We've had a few LBS candidates in our company in the past few years, and we have nothing but praise for them, right? They help the company move forward. They understand the market, they understand the environment, they understand how to navigate this environment. Most importantly, they educate the company on how to do business in Nigeria.
I'm actually looking to go into the FMCG line, maybe marketing, product management, strategy, So I've gotten a lot of feedback as to how these different FMCGs work.
I think that from the interactions I had personally with some of the organizations, that the future seemed bright for us. It seemed like they would take us in for internship, and if not, they are also looking at taking us as full-time employees in 2 years' time, I think. So the experience today has been insightful and good in all of it.
Our experience was overwhelming, very engaging students, very warm and ready to let people know what they have to offer.
I think LBS is doing a great job, and we are very happy to partner with them. From time to time, anytime we're called on, we're happy to give our opinion. And from time to time too, we're happy to come here and see if we can get good talents, that we can onboard to join us in our journey of doing what is right for the economy.
So good coming back to my alma mater because I was recruited from a setting like this. It's all joy for me. It's interesting to be on this other side, to also experience what my recruiters experienced when they were talking to me.
It's actually a very fantastic opportunity to be back as an alumni. I was just a student barely a year ago, and coming back from and being a part of the other side, coming to recruit, talking to students, gives me so much joy.
For us at BNI, it's beyond legal representation. It's about partnerships, collaborations, growth, business. It's about values, numbers, and ultimately national and international impact.
The vision behind BNI was simply to build, create, and sustain the best law firm, at least in Africa, that we compare with any law firm anywhere in the world.
It's been an interesting journey. It's been rewarding in the sense that we're approaching maybe the first level of where we wanted to be.
Okay, thank you very much for holding on and for coming back. And we are going to start the second panel session that I said we focus on ease of doing business. And even though the first panel session went very well, from what we've gathered, we've been assured by our panel members that this second session will be better than the first session. So, and this second session will be focusing on ease of doing business. And joining us to do that, as I said before, we assembled the best of the best. The first on the list is Toyin Bashir, who is a partner in Bao and Igodalo, followed by Shay Bella, who is also a partner in BNI. And to make sure that we have a good balance so that it will be gender sensitive and intellectually sensitive as well. The third is our own erudite Professor Olawale Ajayi. So he will be, he's more or less, he's blessed by having two women with him on the panel. So let me ask if Toyin, Shay, and Prof, are you on and ready to go?
Yep, yes, we are. I believe so.
Excellent. Shay, are you there with us? Shay, are you with us, or are you having internet traffic problem? Prof.
Okay, great, fantastic. Now, I was not allowed to unmute myself, so I was trying to motion and say, hey, I can't unmute myself. Thank you very much.
Okay, excellent, you succeeded. So you passed the traffic, you paid your toll gate.
Definitely.
They've allowed you to come. Prof, are you with us? Let's just be sure that Prof is back. Prof, are you here? Okay, let me start by, as I said, this session will focus on ease of doing business. So let me start by asking the question. I will now try to find out what is holding. Okay, Prof, you're back.
Yes, I was also muted, but thanks for muting me. Yeah.
Okay, thank you very much. So the session is on ease of doing business, how the CAMA impacts or will impact or will enhance ease of doing business. So the first question we go to Madam Toyin. And the question is that it's a common knowledge that SMEs account for most businesses worldwide and are important contributions to job creation and global economic development. And it is like that in Nigeria as well. And also, they represent about 90% of businesses and more than 50% of employment worldwide. I can actually say that there is actually higher in Nigeria. And the question is, are there specific provisions in CAMA 2020 which are geared towards improving the business environment in Nigeria as it affects SMEs in particular. Toyin, please.
Okay, thank you, Dr. Franklin, and good afternoon to our esteemed participants on this session. So yes, one of the primary objectives for the review of CAMA 1990 actually was to create a special legal framework which supports SMEs. And I say this particularly as you know, I worked with other stakeholders on the review of CAMA 1990 when the National Assembly was still considering the bill. And I think it's important and if we have MSMEs on this session, it's important that they also understand that there was a deliberate attempt to actually review that law in the context of how can it actually support MSME growth in Nigeria. So one of the first things that will probably be relevant to set the tone for this discussion is to talk around the definition of a small company, because MSMEs, when we talk about MSMEs, we're actually referring to the small companies as defined in CAMA or any other legislation, which basically identifies that community of businesses. And so the first thing was to review, like I mentioned, the definition of a small company. Under CAMA 1990, a small company was said to be a company which has a turnover of 2 million naira and net assets of about 1 million naira. And of course, this meant that quite a number of MSMEs were locked out of the provisions or any special provisions which were available in CAMA 1990 at the time. So of course, it became very in line, considering the fact that CAMA 1990 was a 30-year-old law, and it wasn't in tandem with current realities. It was important that that definition was reviewed. So indeed, it was reviewed, and now under CAMA 2020, small company has been defined as one having turnover of about 120 million and net asset values of 60 million. So that people understand where they fall, how are you considered to be? And there are other considerations, of course, as spelled in the law, but this is one of the key ones that I guess is relevant for people to pay attention to when we talk about financial threshold. So this was done, and then it was then important to then carve out certain obligations, compliance obligations, which were perceived as onerous. Onerous in the sense that for a company that was, and when you look at new companies, a company that is just setting up and then you're looking at it in context of MSMEs. Now, they're trying to essentially get the business started. And then they have these additional obligations, which may not be relevant at the time. Of course, it becomes relevant with time as they grow. They themselves will be inclined to set up, corporate governance structures. And I know that we took that in the previous section. It will be very relevant. But at the start of the business, it was then considered as a bit onerous. So this is why there are now provisions which exclude certain compliance obligations, which previously were mandatory in CAMA 1990. And this includes exemption, of course, from appointment of a company secretary, which was previously a mandatory requirement, an exemption from appointment of an auditor, and also an exemption from holding annual general meeting. And I just thought to touch on something which relates to this exemption, and this is actually very important just because the Registrar General of CAC also mentioned, their thinking around this particular exemption. So it relates to the exemption to appoint an auditor. So some stakeholders have argued that there's some kind of inconsistency. There is an inconsistency, not even some kind. There's an inconsistency between the definition of a small company under CAMA 2020 and the definition of a small company under the Finance Act, which effectively repealed specific provisions, amongst other laws, specific provisions in CITA. That's the Companies Income Tax Act. Now, in the Finance Act, the small company is now defined as a company with a gross turnover of 25 million naira or less in any relevant accounting year. As most will know, those companies have been exempted from corporate tax. And I guess the thinking of government from an interpretation of that section is that government wanted to provide some form of succor for this category of small companies. And so that was why. But then in relation to CAMA, and indeed it conflicts, because when you have to file your returns, now all companies, whether you're small companies or not small companies, you're required to file tax returns at the end of every year. And you're expected to annex financial statements to your tax returns. So necessarily it means that you have to appoint an auditor. So while there is no requirement for you, a small company, 120 million turnover under CAMA, to appoint an auditor and to file financial statements at the CAC along with your annual returns, or to determine it at the AGM, which you've been exempted from, there is a requirement for you to still do so for tax purposes. And I heard the RG saying, and I've heard this in different, I've heard people discuss this to say that maybe there's a need to then align the provisions of both laws. And in terms of alignment, I think people are shifting more in favor of the provisions of the Finance Act. But I think it's important that stakeholders understand that the essence goes beyond just this particular one. So if indeed small companies end up appointing an auditor for purposes of fulfilling their tax obligations, right? If that figure is revised, and I think the RG said something about substantially, and I hope that that is not the case, quite a number of those MSMEs would now be locked out of the exemptions that we're talking about, that were deliberately inserted in CAMA 2020 to provide succor to MSMEs. So in essence, if you close the gap, it then means that all of those people would then have those onerous, regulatory or compliance obligations, which the intention of the draftsman was to relieve them of. So if indeed we concede to some kind of review, I guess this is an opportunity to also just mention that the regulators should be very cautious about that. Because even the requirement, even the provision in CAMA 2020 that enables companies to set up, that enables persons to set up businesses with one director is only applicable to small companies. So quite a number of those provisions would then apply to them. So we have to be very cautious, and I think it's relevant for me to mention this just because the RG mentioned that you must understand the thinking behind, inserting those exemptions in the first place, so that if you're revising, and I know that the law does enable CAC to do so because it prescribes, and he did mention it, or such other thresholds as prescribed by the Commission. But it could also be argued that at the time, we had a 30-year-old law that was now, the provisions were no longer in tandem with realities, and there was nothing to enable, the CAC to then adjust those figures. And I believe that that was the intention, and not a situation whereby, in essence, the objectives or the considerations of the draftsman are lost just because, we want to match it with the provisions of the Finance Act. And I guess it would be good to mention also the general provisions for SMEs, which relates to, single member companies, the fact that, persons can now set up single member companies, you don't need an additional person. That also would support MSMEs. A lot of the startup business is really the person with the idea wants to set up his business really by himself. Sometimes you are foisted with an additional person just because CAMA 1990, the repealed act, expected you to have a minimum of 2 shareholders. So that is one of the provisions, I guess, that's worthy of note. And of course, there's also the provision relating to statement of compliance, which is an introduction, of CAMA 2020 side by side with the declaration of compliance, which enables persons to, just building on all of the traction that CAC has recorded in digitizing the pre-registration process, and the fact that some MSMEs had to then, engage a lawyer for purpose of the registration because they necessarily had to complete the declaration of compliance. It was put in place to just enable MSMEs to be able to complete their registration processes by themselves. And of course, there's also the provision, when we talk about well, and I think the RGO or Mr. Gidale mentioned it earlier, the provisions that deals with the reduction in the cost of registering charges, that of course was to ensure that including MSMEs can actually, get monies at a cheaper rate because they don't have to expend such monies in registering, their charges at the commission. So I guess these are some of the provisions that are worthy of note in relation to SMEs.
Thank you very much, Toyin. As maybe I didn't say, but you mentioned it earlier. You can see that as Toyin, when she started talking, you can see that she wanted to say so many things, because she was one of the people that reviewed the old CAMA and worked on this CAMA. So I'm sure she has so many things to say. But as I said, I have a breaking news, which I will announce shortly, which will be good to everybody. But let me ask Shay this question. Of course, when we talk about SMEs in Nigeria, and when we talk about ease of doing business, one of the challenges that SMEs have, most of about 80% of them maintain that access to finance remains one of their greatest challenges. So the question for you is, when we talk about ease of doing business, we must necessarily also review ease of access to finance, which is intrinsically linked to how well a business can grow and thrive. So has CAMA 2020 introduced any changes which companies seeking to undertake secured credit transactions should know in order to boost their business activities? Shay, please.
Thanks a lot, Franklin. I think one important factor which contributes to the ease of doing business in any country is cost efficiency. So thankfully, with respect to secured financing transactions, CAMA 2020 touches on this. And I must say that, in undertaking finance transactions or secured credit transactions, one of the biggest challenges is the cost of perfection of security, particularly when you're dealing with security that is registrable. So for instance, you have a borrower or an MSME who is trying to raise capital, and you generally have to deal with paying stamp duty costs and also registration of security costs as well. Now, if you're even dealing with lenders that may accept the concept of partial stamping and its attendant risk, then that you may get some flexibility with the type of fees you would pay. But if you're dealing with lenders who do not understand or who are not able to accept the risks of partial stamping, then what you're basically dealing is, for stamping, you'll probably be looking at about 0.375% of the amount of money you're borrowing. And if you're registering security, then you would have, for a private company under the old CAMA, it was about 1% of the 1% of the loan amount. And then for a public company, it was 2% of the loan amount. Now, thankfully, CAMA 2020 has made a significant amendment. And I think that is for us as practitioners in secured credit transactions. This is a real welcome development because it reduces transaction costs. And essentially, Section 222, subsection 12 of CAMA 2020 stipulates that the total fees payable to the CAC in connection with the filing, registration, or release of any registrable charge shall not exceed 0.35% of the value of the charge. So coming from 1% to 0.35% is X. I know that the RG mentioned this, this morning. And also for a public company who has to deal with 2%, coming to 0.35% is also a significant reduction. The question has ever been asked as to, what does value of the charge mean? Because CAMA does say 0.35% of the value of the charge. And someone has asked, should it be the value of the assets? And there may lie some confusion. I think, and for a firm, we believe that what was intended is the amount secured by the charge, because when you go to Section 223 of CAMA, it does provide that upon payment of the registration fee, CAC is required to enter the amounts that is secured by the charge. So I think that that's a very welcome development, and it will definitely help us in reduction of transaction costs, and it's definitely a big tick for ease of doing business in Nigeria. Another thing to mention as well is that CAMA 2020 also provides clarity about the requirements to register charges. Now, the old CAMA in Section 197 provided a list of security and basically stated that this particular security, what you constitute as registrable security. And what we found as practitioners is that there was certain security that was not listed, in section 197, but you would find that when you're doing transactions, either you have counsel insisting that, or lenders insisting that those particular security become registrable. And of course, having to register those types of security meant excessive transaction costs as well. So CAMA 2020 provides some clarity about the requirement to register share charges and account charges, but I must say that there's some teething issues around definitions, which we hope that the CAC will fix in the issuance of its regulations. Essentially, what CAMA 2020 does is that it provides, especially in section 222, subsection 13 and subsection 14, for the exclusion of security financial collateral arrangements and any security that is created pursuant to this. It removes them from the scope of registrable security. Now, what CAMA does not do is it does not define financial collateral, and which is what we're hoping that it will do in the issuance of the CAC regulations. And this should be very easy because we note that the provisions in CAMA 2020 relating to security financial collateral arrangements mirror the provisions of the UK's financial collateral regulations, which were issued in 2003. And that definition with respect to financial collateral basically says that financial collateral includes cash and financial instruments. And in the definition of cash, it then deals with monies in bank accounts, cash deposits, etc. And with respect to financial instruments, it also then deals with shares in companies and securities. So this kind of provides that clarity that we've been looking for to basically prevent us from going to go and register share charges at the CAC. I must say that as a firm, historically, we have always had the opinion that you do not need to register share charges at the CAC, because we've always taken the opinion that if the law does not expressly say that you cannot do something, then why not? So we have always had that, and it's just very, very good now to see that CAMA has then removed any opportunity for confusion. So I think I'll speak around this specifically for cost efficiency and clarity and certainty that CAMA 2020 provides. Thank you.
Thank you very much, Toyin. As we all seen, as I said, lawyers, they love to talk for a long time. But interestingly, as they're talking, even though they're talking for a long time, they are making very good, interesting contributions, which we are really learning a lot from. But that takes me the question to Professor Jai, and which fits in very well with just what Shay just explained. We understand that there are new business organizations for corporate vehicles from which investors may choose and other which businesses may be carried on in Nigeria under the CAMA 2020. Could you please shed some light on the options available to investors, the pros and cons, if any, of each of the options and how this impacts on ease of doing business in Nigeria?
Well, thank you very much. I think both Mr. Ighodalo and the Registrar General have alluded to this, particularly with regards to limited liability partnerships and limited partnerships. Whereas Lagos State had provision for limited liability partnerships, but now with limited liability partnerships also registrable under CAMA, it does mean that investors or interested parties can trade across the nation without being restricted to Lagos State or the Lagos State law, because formally it would be that in Lagos State you have limited liability status. If you move outside Lagos State, then you probably just fall in the cracks of the partnership laws. So I think this is a welcome development. Of course, you know, most big ticket investments, or let me say, a good deal of big ticket investments also do get carried out through partnership structures, construction, themes. SPVs are very good for SPVs because you really don't want to go through the whole hog of incorporating a company. You want to do the business, particularly if it's a one-off transaction, and then you could use partnerships. But of course, with the limited liability partnership, you then have the advantage of the limited liability status of a company, and enjoy the flexibility and tax status of a partnership. And it's probably also the case that you can withdraw from that vehicle and close down that vehicle a lot more easily. Of course, startups can also decide to come by way of limited liability partnerships. They do not have just to be enterprises or incorporated companies. Then also limited partnerships are also registrable. And of course, the good thing with partnership law is that you can have an investor, a corporate entity, invest in individuals and take a limited or a sleeping partner status. So this is also something that is worth exploiting in the business space. There is a curious provision though, and perhaps Tony would be able to help go through that, because ordinarily limited partners or sleeping partners are not supposed to take part in the running of the organization. Otherwise, they lose their the protection of limited liability. But Section 806(1), maybe there's some drafting error or some or lack of clarity, or maybe it's the version of the law that I'm looking at, appears to give a limited partner some scope to advise the general partners without being deemed to have breached his protection. That I don't know if you have seen that provision, or maybe it's the version I'm looking at. So that's one area where that looks to me to be somewhat unclear. So I think these are some of the, these are some of the advantages. And it has also been mentioned, I believe, by Mr. Ighodalo and I think Mr. Ighodalo, that the application for exemption by a foreign company can now be made to the minister, charged with responsibility for trade rather than the president. Even foreign limited liability companies are sort of tacitly encouraged to come and incorporate within the territory. So these look like assists to ease of doing business. And I think the point that Tony made earlier about lowering the administrative burden for compliance is also a very laudable effort of CAMA 2020. She has also, of course, identified the other part, that doing business is not just about companies and Allied Matters Act. It is the welter of laws, institutions, and regulations that companies must wade through. And I think it's useful for us to then also say, in the Nigerian regulatory space, we need to improve, how's it now, the culture of regulation. There's obviously a whole lot of administrative burdens in Nigeria. No regulations do not go through impact assessment before they are, they're churned out. The better regulations principles that are practiced in some other countries, where you don't have to legislate, you have to think through. Are there other means by which we can get operators to deal with this issue? But in Nigeria, the idea is you churn out legislation without thinking of the administrative burdens for compliance that brings. Of course, there's also the issue of enforcement. I'll stop in a minute, but part of having a CAC is not just to register companies and taking returns and so on and so forth. There's also the need to have administrative oversight in terms of investigations, in terms of training, and I think those are things that we hope will come on board this time. The whole issue about small companies is good to start with them, but you would hope that a CAC will then, after some time, launch initiatives to try to see how to raise the tone of corporate culture in that segment of the business space. So I think those are other issues that speak to ease of doing business that go beyond, go beyond CAMA. I must also say that the length of the statute to me is worrisome. I think the English Act is probably 400 and something, sections. I don't think it's something we should celebrate that the Act is 800 sections. And the need to simplify the laws, the more, I think is the next order of business, as well as constant revision to ensure that they are good for purpose, or they are fit for purpose in terms of enabling business. Thank you.
Thank you very much, Professor Jai. Thank you for that interesting contribution. Toyin, will you want to add something to that, or should I go to the next question for you?
So I just want to talk around what they are. And just because, again, for the sake of, we're having a conversation or a discussion with quite a number of people who are possibly hearing the terms for the first time and want to really understand what those legal vehicles are and how it fits into their business. So I just want to talk a little around, the structures, the different structures. I know that Professor Ajayi has already touched on, some of the advantages and all of that. So just permit me for a few minutes, just talk a little. I want the audience to come away from the session to, recognizing what those two legal vehicles are. So like you mentioned, these are two new, of course, legal vehicles, and it was really in response to the considerations of the review of CAMA to bring it in line with international best practice. They're not new legal vehicles to the world. So many jurisdictions have limited liability partnerships or limited partnerships as part of their business arrangements in whatever jurisdiction, whether in Africa or in other parts of the world. So a limited partnership essentially is a form of partnership similar to a general partnership, which is what we really know in Nigeria, except that while a general partnership must have at least two general partners, a limited partnership, on the other hand, must have at least one general partner and one limited partner. And again, that phrase of understanding what does a general partner do and what does a limited partner do in terms of what are their roles, what are their responsibilities, why is there that separation? Because like I mentioned, in this part of the world, we're used to just the general partners. Now, the general partner in a limited partnership sort of arrangement or structure oversees and runs the business, right? While the limited partner does not undertake, does not partake in managing the business. And I guess that was the point that Professor Jay was making about, the additional provisions, which, introduces some kind of a consulting or consultation, from the limited partner in relation to some of the businesses. So I think, and I guess this will, in implementation, we will see how that works out. It's not that they will be responsible for managing or running the business the way a general partner will, but I think it just possibly affords them the opportunity to just provide some kind of, advice, and an advice is different from, an agreement to do something, you're at liberty to take it or not to take it, but like I said, we'll see how that pans out in, in real terms, in terms of implementation. So the general partner has unlimited liability for the debt and obligations of the partnership, right? So, and then limited partners really have limited liability, just like the name, portends, up to the amount of their investments in the partnership. So that is what it is basically limited to. And so that is the distinction, and that is why, and Professor Ajayi mentioned the fact that it's attractive for a number of, commercial transactions where you have people who want to essentially, bring in investments into a particular venture, but they don't want the additional liabilities of the debts and obligations of the business. And they, basically want to just limit their liability to whatever investments and returns that they can get from that arrangement. On the other hand, we have the limited liability partnership. Now that in itself is a body corporate, and it has a separate legal entity from its partners. I mean, this is very different from partnership, because we know that in a typical general partnership, it's essentially, you're not a body corporate, you cannot sue and be sued in the corporate name. But in the case of a limited liability partnership, once it's registered, the LLP can sue and also be sued in its corporate name. It has perpetual succession and also has capacity to acquire, hold, and dispose of assets in its name. So when you understand the structure, then you see that it fits into different types of corporate transactions. And that was essentially the consideration for bringing it into the CAMA 2020. So the fact that you then have, an arrangement under an LLP where you're a separate legal entity from the partners, and it so can be sued in the corporate name, and then the limited liability, the perpetual succession, the fact that the life of the LLP is not affected, by the demise or the retirement or insolvency or withdrawal of any of the partners. And of course, there's no minimum requirements as regards capital. So then, of course, and then there are the tax implications as well. You don't have to be subjected to corporate tax, because it is the individual partners that are still subjected to their respective taxes. So I think Professor Ajayi had talked on more of the advantages, so I won't, rehash all of that, but I think it's also important that people come out of this session understanding what those legal vehicles are, and then see how that then fits into whatever business venture that they want to embark on anytime soon. So.
Thank you very much, Toyin, for further clarifications on that question. And that takes me to Shay. And the question is that following from some of the updates you already provided as regards secure credit transactions and how these provisions may improve business activities, could you please discuss other general changes introduced by CAMA which would impact financing transactions generally?
Okay, let me also say that one thing that is also important as well with respect to ease of doing business is certainty. And sometimes, I guess, for people who market participants, sometimes it's quite frustrating when you're embarking on a transaction and you don't have sufficient certainty on on the validity of that transaction, what the validity may be from a legal perspective. So what I would say is that CAMA 2020 provides statutory confirmation for the legality of derivative transactions. And of course, derivative transactions like interest swaps, repos, these types of transactions have statutory confirmation for their legality. Now, even though derivative transactions are common in the Nigerian financial markets, there have been questions as to the validity of these contracts in view of the Gaming Act. Now, the Gaming Act basically provides that contracts that are of a wagering nature of a speculative nature are void. And so essentially, because derivative transactions or derivative contracts have some speculation, there was definitely that question as to whether or not, from a legal perspective, since you had a law that was basically saying that these types of contracts are void, whether or not these contracts as well, the derivative contracts, had some validity. So now it's very clear that in section 720 of CAMA, and section 720 of CAMA now clearly provides that a qualified financial contract shall not be and shall be deemed never to have been void or enforceable by reason of laws relating to gaming, wagering, gambling, or similar laws. So this provides the statutory certainty with respect to derivative transactions. Now, I'd also like to touch on the provisions of Chapter 28 of CAMA 2020. And this is, I would say, from a financial markets perspective, I say this is indeed a very, very, very welcome development. Nigeria has finally become a netting-friendly jurisdiction. So now just talk a little bit about netting so that people understand that. So when you say that a country has now become a netting-friendly jurisdiction, what essentially you're saying is that it is a jurisdiction that has entrenched the enforceability of close-out netting provisions in its domestic laws, particularly as it relates to insolvency. So you find this close-out netting provisions in agreements like your ISDA, so your International Swaps Derivatives Association Master Agreement. You'll also find them in your Global Master Repurchase Agreement, your Global Master Securities Lending Agreements, and these close-out netting provisions are now enforceable in Nigeria. Now, if I can just talk a little bit about netting and just give a basic explanation. The most basic explanation of netting is that I would say that netting is basically offsetting receivables against payables between companies so as to arrive at a single net obligation amount that is now payable by one party. And the benefits of this, is you can't even emphasize how beneficial this is. And this is because, for instance, what it does is that it mitigates the risk that one party pays a gross amount under a contract and the other party then fails to pay. So one party would have already moved a gross and the other party fails to pay. And then you then have an issue with counterparty risk. But what netting then does is that by aggregating the gross amount, you are reducing settlement risk. And the only thing you then have is only a net amount is at the risk of not being paid. And then imagine that you can also have reduced administrative costs that come from multiple transfers and etc. So netting is really, really, really a big deal in the financial markets. But I think that what is important to then stress is that CAMA 2020 focuses on close-out netting. And I guess the way to explain this, or for you to see the usefulness, is to make a distinction between the contractual right of set-off and close-out netting. I'm sorry, if you think I'm getting a bit technical, but just this is just so that people understand how important this is and the value or the benefits of having this provision in CAMA 2020. So everybody understands your original type of right of set-off. So with the traditional right of set-off, you typically are not able to exercise that right until the underlying obligations are due. And what this means is that if one party becomes insolvent and its obligation to pay is not yet due, then you're not able to exercise that right because from the liquidator's perspective, that obligation has not yet become due. And therefore, it will be liable to avoidance under principles of insolvency. Okay, now this will be quite dangerous with derivative contracts because derivative contracts are basically open contracts. So what you basically have is you have different people taking different positions. And what you then have is those contracts are basically open. So the obligations are not due until you specify this, until you put a particular date by which you say, okay, look, this is the particular dates by which we will then have due obligations. So what does closeout netting do? So closeout netting then says, okay, before the settlement date that the parties have agreed, if you have an event of default, or if a party becomes insolvent, now these events are usually defined as termination events. So once a termination event then occurs, the existing transactions between the parties will then be terminated. The payment obligations the parties owe each other will then be accelerated and they'll become due automatically. This is what you would not have under your typical contractual rights of insolvency. But what then happens as well is that the values of these transactions are now calculated, they are netted, and they are replaced with a single net obligation. And that net obligation then represents the aggregate value of all the combined payment obligations. And that net amount is paid as a lump sum amount to the party that is owed. So basically, that party is basically preserved, notwithstanding insolvency. And what basically it means is that even though your obligations have not become due, the settlement date has not happened, by virtue of closeout netting, all those obligations have been accelerated and they can become payable. But the challenge is that if closeout nettings are not enshrined in the domestic laws of a country, then what will happen is that the principles in insolvency will supersede the ability to be able to undertake closeout netting. But now, we now have this. In fact, netting is defined in section 718 of CAMA 2020 as the acceleration of any payments or delivery obligation, the calculation of closeout values in respect of each obligation, followed by the aggregation of these closeout values in order to arrive at a net balance. So we can see that CAMA 2020 has definitely enshrined the principles of netting. And in fact, section 721 of CAMA 2020 provides that the provisions of a netting agreement will be final and enforceable against an insolvent party. And so those netting arrangements cannot be suspended by a liquidator, and they cannot be removed because of principles of insolvency. And so I'm sure that right now, if that is not already happening, I'm sure that the ISDA will definitely be reaching out to Nigerian law firms to ask them to provide legal opinions on the applicability of closeout netting or enforceability in situations of insolvency, as now stated in our CAMA 2020. And so what do we have basically? We now have a situation where CAMA 2020 achieves its aim of providing a high level of certainty as to the enforceability of closeout netting provisions, and therefore protects the parties from any operation of law provisions that may take place from an insolvency perspective. Thank you.
Thank you very, very much, Shay. You asked a question if you are getting technical. Yes, you were very technical. I actually thought I was in a finance class, but just with a little bit of laws in it. So, but it was very, very, very insightful. But let me go back to Professor Ajayi. Professor Ajayi, please don't be technical. I want you to bring it down very, very, very well. And it's just a simple question. Does this new act facilitate ease of doing business? So that somebody that has a salon somewhere, somebody that has a small business somewhere will understand how the act affects or facilitates ease of doing business. All the things that Shay explained, excellent, fantastic, but it requires you to have an understanding of law and finance to grab it very, very well. But she tried to bring it down, but of course, as a professor of law, we want you to bring it down. Please, they ask somebody, are you already on the ground? He said, I am on the, but I'm digging, I'm still digging down. So please dig down further with regards to what Shay asked. So you've talked about issue of limited partnership, limited liability companies, but generally, what do you think about this new act? Does it really facilitate ease of doing business so that we, the common people on the street, can understand what it's all about? Thank you, Prof.
Well, all that Shay was talking about is probably more applicable to those who are interested in insolvency and in derivatives. I'm sure FMDQ is very happy as far as this is concerned. Although I must also say that, well, as far as derivatives is concerned, someone called it as, was it Warren Buffett, who said that derivatives are, was it now, nuclear time bombs. So that's something we need to watch out for on another level, maybe not from the point of view of CAMA, but the fact that derivatives business is going to be much enhanced in Nigeria does mean that all the institutional safeguards and frameworks that need to be put in place to ensure that the economy doesn't suffer by the misdeeds of derivatives trading are also put in place. I think for your pepper seller or whatever it is, we've already discussed the advantages of the act, and that will be at the level of the ease of incorporation that it offers to entrepreneurs. This whole idea of single person companies, small companies, the fact that you can issue a statement of compliance yourself. You don't have to have a lawyer advise you. The exemptions in terms of administrative arrangements. These are the areas I think that, when you come down to the street level, you will say that it does help, or it may help the small person to have the limited liability to also be able to use the corporate form to advance their business. Of course, the simple point is that limited liability is liability protection. So I think that encourages entrepreneurs, because you can fail, and know that you don't have to lose your shirt or the shirt on your back. I think that is probably the comfort that the person in the street or the small entrepreneur will gain from the act as far as ease of access is concerned. In terms of ease of doing business generally, the technical points are very good, particularly from point of view of ensuring that ensuring creditor protection, ensuring more transparency. Maybe we'll talk about this later on. Ensuring more transparency. Therefore, that means that you are, so to say, allowing other stakeholders a fairer deal from company management. I think those would be strictly technical aspects, but ease of doing business, as I did say earlier on, goes beyond registering companies or dealing in business with corporate forms. You also have to think about issues related to, the judicial system. If you have issues, can they be settled quickly in the courts? And some of what Sheyi spoke to may address at the high level issues of the judicial system. Issues relating to access to finance, which would not necessarily be in CAMA, but CAMA can aid that, would also be important. The mere fact that you incorporate a small company is not going to make the bank give you, give you loans. And maybe we also need to say that suppliers and creditors also ought to become conscious of the fact that these single person companies also represent risks, and you need to look very carefully before you deal with them, because don't be taken away by the fact that they are limited. It's really, some of them would simply be one-man companies with the advantage of limited liability, and you still have to do your due diligence to ensure that they're worth doing business with. And I think that is where Tony's point about still ensuring that they have audited accounts, or that they keep books of account, they try to ensure that they have structure, will also be useful. But you can say maybe at a particular level, that will become very important. But if you just want to start, I think the CAMA gives you the opportunity to, instead of doing it from from your sitting room, you can incorporate, and that gives you the honorific of running a limited liability company, protects you, probably gives you a honorific from the point of view of people you are dealing with as well. I hope that brings it down to the ground level as you suggest, as you require.
Thank you very much. I think you reached the ground floor, which is fair enough, even though you didn't go to the foundation, but we leave it at that for now. But it was very, very good. It was at the ground level. Thank you very much. Let me take it back to Tony. And the question is, as we try to bring the sessions to a gradual close, is under the repeated CAMA, under the repeat CAMA, the obligation to disclose beneficial interests was restricted to public companies. However, CAMA 2020 does not make a distinction between disclosure required by a public company and a private company. So it will appear that this requirement has now been made applicable to both public companies and private companies. The question is, what are the provisions on disclosure of beneficial interest and significant control, which have been introduced under CAMA 2020? Why do you think that these requirements were extended to private companies? And do you think that this disclosure requirement will improve or hamper ease of doing business in Nigeria? Toyin, please.
Yeah, so thank you, Dr. Franklin, and permit me, please, if I can just say a little something about the discussions that Professor Ajayi just took, just to weigh in and say, just to clarify also a little bit around the fact that, I mean, so there was the discussion around registration on companies being one of the things that is important for doing business. I just wanted to contextualize that in interactions with a lot of small businesses, you will find that even just the action of registration is a problem. So moving them from informal sector to formal sector, I mean, so there's the advantage for government, but more important in terms of, tax and, the fact that they would now be within the tax net, but then also in terms of the economy as a whole, you now find it that more people would then move from the informal to formal, and will continue to then push government in relation to things like access to finance. So that's a different thing. And so you must first start from how easy it is for you to start your business. And then you now go on to access to finance. You see all those, essentially all those palliatives that was introduced by the federal government and some state governments and even some banks for MSMEs. But if you're not registered, you can't access it, and I think the CAC had mentioned in one of the discussions that I listened to that they witnessed quite a number of movement from informal to formal during, COVID, because a lot of MSMEs then realized that in order for them to access, that finance, they needed to move to the formal. So we can't underestimate really how it's important to set structures to ensure that that movement is at least very easy. It's cheap, it's timely, and is accessible. So going on to the question that you mentioned about disclosure, and I think Olumide had already pointed out why it's even important to have disclosures in the first place because of transparency. It fosters investor confidence. It's essentially good for business because again, you can then attract investment. So that definitely is also part of the broad agenda of ease of doing business. So while under the repealed CAMA, the disclosure of beneficial interests and substantial shareholding was only in respect of public companies, like you rightly noted. Under CAMA 2020, although the requirement for disclosure of beneficial interest is still only for public companies, it introduces the disclosure of significant control by members of all companies. So that's public and private. So by virtue of section 119 of CAMA 2020, every person that has significant control over a company is expected to, within 7 days of attaining such significant control, now must give notice in writing to the company relaying the particulars of such control. And of course, the company in turn is expected to then notify the CAC of such information within a month of receiving same. The company is also expected to disclose such information in the annual return filed for the relevant year. So under the provisions of CAMA 2020, the Commission now also has an obligation to maintain what is now a register of persons with significant control, based, of course, on the information that is received from the company. All these are just disclosures. There's nothing mandating them other than the fact that they are now required to do it under law. And I believe that CAC will prescribe penalties for non-compliance with these provisions when it issues its regulations. Now, I think it's also important to note what exactly are these people, who are these shareholders, who are these persons who are described as persons with significant control. So in the interpretation section of CAMA, a person with significant control has been defined as any person who directly or indirectly holds at least 5% of the shares or interest in a company or a limited liability partnership. And I think, I don't know if the RG mentioned, so for people who are now more interested in setting up limited liability partnerships or limited partnerships, that is going to take some time before they deploy, the technology solution that would enable them register such companies. So that's not coming on board at the moment until CAC goes through its procurement process and then establishes a process online for registering such companies. So in addition, a person with significant control is also someone who directly or indirectly holds at least 5% of the voting rights in a company or in a limited liability partnership, or directly or indirectly holds the right to appoint or remove a majority of the directors or partners in a company or a limited liability partnership, or otherwise has the right to exercise or actually exercises significant influence. And I guess this is some of the discussions we'll be having in courts for some of these cases, to now determine who's this person who has exercised significant influence or control over a particular company in terms of the decisions of those companies or limited liability partnerships, or has the right to exercise or actually exercise significant influence or control over the activities of a trust or firm, whether or not it is a legal entity. And again, this is going to be interesting to see in terms of implementation. Worthy of note is that this provision is very similar, to the UK companies law, but only that the UK prescribes a higher threshold of 25%. So we then have the disclosures in relation to substantial shareholders. Now, substantial shareholders have now been, CAMA 2020 essentially has expanded the duty of shareholders to disclose acquisition of substantial shareholding to all companies, including private companies. So this disclosure requirement, it was only applicable to public companies, but all companies are now required to file particulars of their substantial shareholders with the CAC within a specified period. CAMA has also revised the definition. So previously in CAMA 1990, it was restricted to persons who exercise at least 10% of the unrestricted voting rights at a general meeting. But CAMA 2020 has reduced the threshold to 5%. I mean, and this is pretty interesting because, again, and I think I would say it's a welcome development as well, apart from the fact that it's interesting, because it essentially aligns itself, it has aligned those provisions with some of the regulator-specific provisions around substantial shareholding. So for instance, Article 2315 of the Code of Corporate Governance requires the board of directors of a company to ensure that the current information on the ultimate beneficial owners of the major shareholdings or any shareholdings owning, controlling, or influencing 5%. So this is the reference to the same 5% in the Code of Corporate Governance. Also in the Nigerian Stock Exchange rules, specifically Rule 7.4, also mandates that a dealing member shall disclose in its annual accounts a list of shareholders with 5% or more of the share capital. So you would say that this is it essentially resulted in an alignment of what was seen in practice, and not just only seen in practice, what was seen to have worked in practice. So, and this is why it is considered a welcome development. I mean, in closing, and I want to bring it home as to why those disclosure requirements are pretty important, especially as regards perception, because this is an ease of doing business session, And I believe that this provisions also satisfies Nigeria's commitment a couple of years ago to the Open Government Partnership, of which it is a member, to ensure that these disclosure requirements were codified. I mean, it has to do with, things around asset shielding, financial transparency, just essentially things that has to do with perceptions of most countries around how they deal with asset shielding. So it contributes to the perception of the country. It helps to improve the perception of the country. These new provisions, to my own mind, helps to improve the perception of the country in regards to its obligations on a broad level in relation to those international affiliations, including the open government partnerships, and also for investors who are encouraged by the level of transparency given those provisions in the law, and essentially, of course, dovetails into the growth of the economy. And so this is why I feel it is relevant to ease of doing business.
Thank you very much, Toyin. Very detailed explanation. Let me take it back to Professor Jai as my last direct question to you with regards to this particular session. But of course, when we come to questions and answers, some questions might still come to you, Prof. But so just leaving the legal or the technical legal issues again, or let's just bring it down again. In what ways does this act serve to raise the tone of ethical performance, likely to send the right signals to investors? Prof, so in what ways does the act serve to raise the tone of ethical performance, likely to send the right signals to companies? Thank you.
Okay, I think, of course, issues around transparency, accountability, accounting, declaration of dividends, returns, disclosure of significant interests. I just suffered was it now electricity outage, so but at least you can hear me. I mean, those are shall we call them, those are orthodox measures, of course, that speak to transparency. Issues related to meetings. I think basically what one may say is that the usual provisions that help to ensure that directors are accountable to shareholders are in place, subject, of course, to the fact that the power of day-to-day management remains, conferred on directors. Issues relating to protection of minority shareholders are fairly bespoke, but these are also areas where you're talking about transparency and ethics. In private companies, the rule that separates chairman and CEO certainly is worth mentioning. I think that would be the way that I would probably bring it down home as raising the tone of ethicality. I think there's also the provision that says public companies should upload their returns to their websites, even though I'm not too sure whether that will do much. But the fact that you don't have to go to the, to the stock exchange or the registry in order to have a view of the performance of the company is certainly a step in the right direction. Those are the areas that I think immediately come to my mind here. I don't know if the other colleagues can point out to some of the other significant provisions or new provisions that raise, transparency and ethics, and which are likely to send a good signal to investors, I think local investors and also outside investors. Of course, the issue of independent directors is likely to play well in terms of wanting to raise the tone of corporate governance. Trying to ensure that audit committees are financially literate. I think these are things we have spoken about, which probably will seem to raise issues about ethicality. Even the provision on directors having regard to environmental issues in their in their operating environment, which speaks to environmental, social, and governance risks, does mean that if you align that with the NSC guidelines and the code provisions, hopefully you will have directors concentrating their minds on looking at risks and managing those risks better. I think one of the points that the stock exchange mentioned in introducing the sustainability guidelines, and if you read the sustainability guidelines, is that companies that take the pains to, properly manage their ESG risks are usually some of the best in the world. So I think those are areas in which one can hope that we will go beyond the provisions of the law to actual practice. And so we shouldn't sort of feel El Dorado, the law has been passed. The harder work is in ensuring that these principles are driven into practice. And that's where the code and other institutions will matter. Thank you.
Thank you, Prof, for, I think you are really bringing it down for all of us to really understand very well by touching on so many issues that will help to raise the ethical dimension of this act. Thank you. Just because of time and other things that we planned for this session, I have a breaking news which I have not disclosed, which I will do shortly. So we take just 2 questions, and I will now give the breaking news, and I will also invite Dr. Jumoke Ojuwole to give the closing remark. But before I do that, the first question is, does the new act expect private companies to disclose the investment of shadow director? I mean, it's open to Shay, Choyin, and Prof. Does the new CAMA Act expect private companies to disclose the investment of shadow director? Anybody, please?
Hello?
Hello?
Can you hear me? So sorry.
Yeah.
I was trying to get on mute as well. I mean, so there was no specific provision in relation to shadow directors, but to the extent that their disclosure requirements apply to all shareholders and so necessarily covers all investments, I would imagine that it does extend to shadow directors insofar as it relates to the shareholding of such directors.
Yes, Toyin, sorry, this is Aziza, because I already answered the question during the chat that certain sections of CAMA apply to shadow directors. There's 279, there's 301, 307, 311, and 312. So there are certain specific obligations that are also imposed on shadow directors in CAMA. I answered in the chat already.
Okay, thank you very much.
I assume, Toyin and Aziza, I assume also that shadow directors, whether you declare yourself a shadow director or not, the legal provision is such that it can also attach liability to you if, in fact, you are seen to be a shadow director.
Yeah, that's correct.
That's correct. Those were the sections that I called up. One of those sections that I called up.
Yep. The last question is with regards to issue of key man risk. Is there any provision on how this will be mitigated or managed? It's an open question as well. Key man risk.
Key man risk will have to be dealt with by the company itself. I mean, so you can decide to take insurance for the benefit of the investor. And I think this is one of the things we're talking about, that in easing business, you also need to make those companies be structured in such a way that it's very easy to raise capital. When you do capital raising transaction or a one-man company is trying to raise capital or bring in investor, from a legal perspective, you always have to do a lot of governance structure and put so many things in place. So again, is why we've said that in loosening and making it easy to formalize the informal sector, we need to put in some checks and balances. The law is not going to make provisions for key man risk, right? You need to make provisions for key man risk and ensure that you have adequate succession plan. That's when which Mr. Agudalo alluded to, that the risk of having one shareholder and that shareholder dies, who continues the business, is a risk that we will have to live with if the company doesn't adequately have succession plan in place.
Dr. Franklin, I see that there's also a question with respect to closeout netting. So if you don't mind, I'll just answer that question. So there's a question
quickly.
Yeah, there's a question that says that, does the closeout netting provisions of CAMA, or can the closeout netting provisions of CAMA be applied to circumstances of force majeure? And I think I just wanted to clarify that closeout netting is a specific provision that relates to derivative contracts. So it's not that you're just going to apply to any type of contract. And I also just wanted to mention as well that with respect to derivative contracts, you would see that I think it's section 5 of the ISDA Master Agreement specifically lists out termination events and lists out the specific types of events of defaults and termination events that then qualify for things that would give a person or a counterparty a right to terminate. So this is quite different from your usual contractual type of force majeure. And one has to also understand that it's the benefits of having closeout netting provisions and the recognition of trading in financial instruments and securities that has prompted the need to then have this recognized, in the CAMA. So this is different from your usual type of force majeure. So I just wanted to clarify that.
Thank you very much, Shay, for that clarification, which I know will be very helpful. But on this note, I say a very, very big thank you to all the panel members. We have many other questions, but all these questions will be answered when I give my breaking news shortly. Let me, on this junction, invite a kind of bringing it together. And we couldn't get a better person than the person that we got. And that's Dr. Jumoke Oduwole, the Special Advisor to the President on Ease of Doing Business and Secretary of Presidential Enabling Business Council. So Dr. Oduwole, please, for closing remarks.
Good afternoon, everybody. It's really a pleasure to be here to join you on this session. What looks like has been a very engaging morning, very deep questions from the participants. I'm going to do a kind of brief recap, just tie it all together, as you said, because you've had really all the best speakers that could possibly have commented and taken you through, but I thought, okay, let me give a brief overview. At the special request of Mrs. Bashir, actually, I thought, what's left to say? It's all been said. So I'll just take you through a very brief. Akunu, please, can you share your screen? Yeah. So I'd like to speak briefly about the journey that got us here and how I hope that this journey in collaboration will not be the end. Getting CAMA reenacted after 3 decades is not an end in itself. It's really actually the beginning of a journey that shows that collaboration works. And we have a winning strategy here. So I think that's the key message I'd like to share. Akunu. We're having technical difficulties. Where is he? 1 second, please.
Can I send them to you?
Can I share my own screen from here?
Yes, please go ahead.
Okay, he wasn't allowed to share, so I'll share from here. Let me just get them done. Okay, we have the slides. Are you in?
It came up and suddenly disappeared again.
Let me try again. Let me see. Can you see my screen now?
Yes. Yes, we can see it now, yes.
Okay. Akun, is that my screen or yours? Okay. Okay, we're on. So yeah. So I'm sure you already were briefed very along the way. Someone may have mentioned it, that the CAMA is a journey of collaboration, but the Presidential Enabling Business Environment Council did deliberately put in at least 15 new provisions centering on ease of doing business to remove bureaucratic bottlenecks across. So the timeline, I think it's important to note that the current version of the Act was first introduced to the National Assembly in 2013. But some of the most novel provisions were put into the draft in 2017 by the PEBEC Secretariat. But the section of business law of the Nigerian Bar Association engaged the CAC in 2016. The Eighth National Assembly played a very important role, particularly through the National Assembly Business Environment Roundtable, which was basically lawyers and business owners, SPL and NESG. And the former Senate president championed the passage of the bill through the National Assembly and instituted a technical advisory committee to review the bill in 2017. And that bill had broad representation, including from the SEC, the Nigerian Stock Exchange, law firms and capital market operators, and some technical partners. Now, going to that story, I'm sure you all know the objectives. From our perspective at PEBEC is to make it easier to start a business and easier for everybody to run a business. And we focus primarily on small and medium-sized enterprises. Transparency and better governance is very important to us, and we just want to make it more efficient. So some of the highlights, some of the most innovative provisions, I've already heard you discussing them, and also discussing the risk, single member, single shareholder company. You also have a lot of the electronic filing, electronic share transfer, e-meetings for private companies. You have virtual annual general meetings also. These are things that were passed way ahead of COVID, and you can see that we were ready for it. CAC was ready mentally for it. Everybody, National Assembly was aligned that this is the way to go. So Nigeria was already in good stead, even at the break of such a pandemic. Now you've already been talking about different structures in formation of a company. You can have your single member, single shareholder. You can have your limited liability partnership or limited partnership. You can have a public company, a private company, plain vanilla, 2 or more members. It's to give private sector options. They have different tax liabilities, they have different risks, they appeal to different types of entrepreneurs, easier to do business. Incorporated trustees, I wonder whether you had interesting discussions on incorporated trustees, but there it is. One of the things that can happen with incorporated trustees is that they can now merge, which they couldn't before. And of course, everybody knows there's been a lot of controversy trailing the greater levels of oversight that will be given to incorporated trustees going forward. So some of the long-awaited provisions that private sector participants had been putting, private sector stakeholders had been bringing to the fore over the years was not being happy about having to tie down so much authorized share capital. So it's been replaced with minimum share capital. And that just means that it's cheaper to do business because you're not tying down money that you can do for other things. Also, the registration of charges, the regime has come down quite significantly. We're expecting about a 65% reduction associated in the cost of doing. Always a pleasure for private sector to do business cheaper in Nigeria. Introduction of statement of compliance. This is a simple measure. I told you we focus a lot on SMEs. Instead of having a declaration of compliance where you need a lawyer to sign or for it to be attested before a notary public. A promoter can simply sign a statement of compliance, and the government will take you at your word. And so it's easier and cheaper to do business, unless, of course, you're found to have wrongfully declared something later down the line. Exemptions from the appointment of auditors, also the appointment of company secretaries for smaller companies, cheaper and easier to do business. Common sales are something that's a relic way from, way back from the British law. And common law, basically, we're just tidying up, removing this relic in our laws. It need not be there, and in practice is rarely used, but was still mandatory under the law, and certain transactions needed it, but now we're doing away with it completely. Some of the highlights of the provisions to promote accountability and transparency. I already heard you talking about shadow directors just a second ago, but significant control in companies now needs to be disclosed. Beneficial owner, nominee, whoever you are, whatever you're doing, this will limit incidents of fraud in our climb. Reduction of multiple directorship in public companies. You can only be a director of 5 public companies at a time, just to limit insider trading in Nigeria. So it's more transparent to do business here now. Business rescue provisions, very important. As you know, our insolvency laws had been at an infancy stage for a number of years. Indeed, the practice had far overtaken what our laws provided for. So we worked very hard to deliver these business rescue provisions for insolvent companies so that they're not cannibalized by creditors. Rather, companies have the opportunity, some of the wiggle room to go into voluntary arrangements and netting. Minority shareholder protection, also an important area for us. Of course, this just brings to par what has been in company codes for a number of years, that you should not be a chairperson and chief executive officer of a public company. This has been global best practice for a number of years, but it had not been expressly stated in Nigerian law. So it just makes it firmly more transparent to do business in Nigeria. For us, what next? I think I'm very happy to talk about this one. The Omnibus Bill on Business Facilitation. So the PEBEC Secretariat had been working with SBL and NESG since 2018 on an omnibus legislation, which is when you scoop across legislations in a business climate and you look at where you can have quick amendments. So it's a tool for making amendments to existing laws that's used in several jurisdictions across the world. So about 40 law firms worked pro bono on this, also with NESG and the Ministry of Justice, and were able to put together a draft bill. Now, with the passage of the Finance Act in 2019, at the end of 2019, and the CAMA last month, a number of the provisions in that draft bill have been subsumed into law. So we're calling for additional input, and that's the website, that's the email account that you have there. And that's basically it. So what I would like to say is that it's been a journey. It's been an exercise in collaboration. Several stakeholders came together to deliver this. It'll be remiss on my part if I didn't especially thank and recognize Mrs. Toyin Bashir from Bawani Godalo, who has indeed been the lead at the PEBEC Secretariat, the head of legal for about 3 years now, yes, on loan to us from Bawani Godalo, even though they took her back, but she stayed with us to just see us through in the CAMA, and will also work with us on the Omnibus Bill. Now, the importance of partnership, private sector and government, is that with such a resource person, partner level from one of the leading law firms, embedded in a government secretariat, pro bono, like just given to us that technical resource, we were able to move a lot faster than we ordinarily would have. So we had younger lawyers under her leadership, and they basically midwifed the CAMA process from 2016 when she came on board till assent on 7th of August, and also worked on the omnibus bill drafting. She also coordinated that process with SPL. SPL had an elaborate team, a committee chaired by Sheni and Adio, and then Fola also handling the technical committee. So a lot of private sector expertise coming alongside government in a transformational manner to collaborate with a ton of stakeholders across the board. We're talking about, apart from the Corporate Affairs Commission, and I know you listened to the very competent Registrar General earlier in the morning, you have capital markets operators, you have business owners, you have organized private sector, Lagos Chamber of Commerce and Industry, Manufacturers Association of Nigeria, all sorts of stakeholders have stayed very, very close to the PEBEC and helped us as we build trust and collaborate and deliver what is by all standards a landmark legislation for Nigeria after 30 years of trying to get it done. So I would just urge everybody, please support the omnibus bill, and please be a convert of, we don't have to wait another 30 years. If there are provisions that, in your opinion, would need amendment, or there are suggestions to move the business climate even further along, because we're not going to rest on our oars, please very quickly document them and start sending them in. Let's start having conversations. Let's start engaging the Corporate Affairs Commission. And once they come, because you heard the Registrar General, his arms are wide open. That's in actioning the CAMA 2020, in all the schedules, in all the regulations that need to be drafted, and the Minister of Industry, Trade and Investment as well, very committed to that process. And in terms of going back to the National Assembly for further amendments and taking our business climate even further, we're ready for the challenge, both with the Omnibus Bill, with CAMA. We've worked on several other legislation. We worked on competition law. We worked on secured credit. We've worked on a number of legislations with the National Assembly. Very good partnership there. So I guess my parting shot would be that collaboration works, and let us seize the opportunity. We've seen what works. We've seen how it works, and we have a winning formula. So thank you very much for having me, and congratulations for a very well attended and very vibrant discussion. Thank you.
Thank you very much, Dr. Oduwole, for that interesting closing remarks. Let me say that when Mr. Igodalo finished his lecture, I started feeling like a chartered CAMA expert. But now that, after your closing remarks, I'm now feeling like a certified chartered CAMA expert. So thank you very much. On that note, I say a very, very big thank you. There are so many people. I'm sure we've had a very interesting session, very insightful. The contributions are excellent. But let me make the breaking news. There are so many questions. We had about over 700 people logging in and listening to us. And we have so many questions. And of course, you know, there was a time we had a Honda car that is popularly known as discussion continues. And based on from what Dr. Oduwole said, the discussion continues. And that discussion, the breaking news is that on 15th of this month, which is Tuesday, we've also arranged that this discussion will continue with Professor Ajayi and Madam Toyin Bashir appearing 11 o'clock on AIT Morning Line. So all the questions will also pick it up so that it will reach the larger Nigerian audience. So it will be 11 o'clock on Tuesday, 15th of September with Nancy Morning Line. So please join, and any questions you have, they will ask it. We will collect all this and they will pick it up when they are answering the questions on Tuesday. So in terms of people that we can say a big thank you, there are so many people we can say thank you to. Let me start by saying a big thank you to Dr. Jumoke Oduwole, not just because of your presentation, but because of all the things you've been doing, all your hard work with regards to ease of doing business, the President Enabling Council. I mean, Nigerians are noting it, and we urge you to continue to do more. Even though some of them are on pro bono, but please continue. We're all hoping and praying that Nigeria will be a better place. And also, we say a very, very big thank you to the Registrar General of Corporate Affairs Commission, Alhaji Gaba Abubakar, for what they are doing in CAC and the way they are doing some of the reforms. And of course, with CAC, PEBEC, Ease of Doing Business Committee, as Dr. Duwale mentioned, partnership will lead Nigeria to a better place. And on that note, I say that this seminar wouldn't have been possible without a partnership. And that partnership was between Lagos Business School and Banwa Ighodalo. And of course, I will say a big thank you to Aswe Ighodalo, the founding partner of Banwa Ighodalo, and also to Femi Olubanwo, also a founding partner, and Kenny Tim, the managing partner, and all the partners of Banwa Ighodalo, particularly Aziza, Toyin, Olumide, and Shei, for all your interesting contributions, and all the partners and employees of Banwa Ighodalo. Let me say that on behalf of the Dean of Lagos Business School, we say a very, very big thank you. We also appreciate the contributions of Professor Olawale Ajayi and other people from LBS that really worked behind the team, the IDT people, and other people that supported us to achieve this. But as I said, the discussion continues, and with partnership, we believe that Nigeria will be a better place. So thank you, good afternoon, and have a good day. Thank you.
Bye-bye.
B&I, it's beyond legal representation. It's about partnerships, collaborations, growth, business. It's about values, numbers, and ultimately national and international impact.
The vision behind B&I was simply to build, create, and sustain the best law firm, at least in Africa, that we compare with any law firm anywhere in the world.
It's been an interesting journey. It's been rewarding in the sense that we're approaching maybe the first level of where we wanted to be the best law firm in Nigeria.
And to sustain it, we have to keep improving, getting better, bringing in technology. The world is moving in certain directions. But the work we do, it must be technology married with people. For me, it's always about people.
B&I is a first-class law firm with over 28 years of excellent service delivery. Consistently ranked as a leading first-tier law firm in core 5 practice areas: intellectual property and technology, which includes our media and entertainment law practice, litigation, arbitration, and alternative dispute resolution, energy and natural resources, which houses its oil, gas, power and mining practice areas, shipping, aviation, and international trade, and corporate securities and finance, wherein sits its M&A practice as well as its project finance and private equity practice areas.
We hope that, first of all, you'll have a very nice and pleasant time with us, and you'll come away with something that you'll find useful for your own endeavor, for your own business, for your own enterprise. Welcome to Banwa Ighodalo.